Hi, y'all, and welcome to the all day live stream of day 8 of the Donna Adelson trial. It is her second day of her defense. The state went for 6 days. Now, this will be the second day. We will have the defense on today. And what will they do is the huge question everybody is wondering. Yesterday, we heard from numerous friends of Donna's. These were people who had been friends of hers in her life prior to the time she was arrested, some of them before anything happened with Dan Markel. And these people came and talked about how she was a nice person. They talked about her general character, and they talked about the fact that she didn't hate Dan Markel. They also talked about her reaction when she heard about the death of Dan Markel and how she was very upset about that and devastated about that. At no point did they ever get the idea that she wanted Dan Markel dead. That just didn't happen. So we heard that yesterday. The defense has had several strategies, I think, so far. One is the friends, sort of humanize her, make her seem like someone who is clearly just an ordinary person, an ordinary grandmother, at least an ordinary Jewish mother, as one of the witnesses was asked. And he said a more than ordinary Jewish grandmother because of her role in the grandchildren's lives, because of the fact that Dan Markel has been actually has been missing from their lives. He was the one murdered, of course, and therefore they didn't have their father. And she was extra involved because of that. So they all talked about her as just a regular, ordinary person. That's a typical tactic, a strategy to humanize the defendant so that instead of seeming like a really evil, scary person, there's someone who could just be an ordinary person caught up in these events, not having anything to do with the actual murder. Another strategy they used was an expert who talked about the cell phone evidence. They really wanted to separate Donna from Charlie and Donna from the money that went ultimately to the hitmen. We all know that when Charlie was at his house that evening of Dan Markel's murder, a witness has come to trial, Katie Midbanawa, his girlfriend, and she said she went to his house that night. He gave her, they're starting. I don't want to miss. Oh, this sounds really good. We're going to go back to the beginning. He said, I'm not accusing the state attorney's office of doing anything. Well, let's hear what this is going to be. Let me go ahead and add that to the stage, and we are not going to miss a minute. So I'll back up about 10 seconds.
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in under Sheriff Google, however, at this point in time, this does not invoke the court to need to go through an inquiry. The witnesses that you're referring to, have they been disclosed to the state?
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the sheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense? We are asking for the court's assistance because the rules,
To do what exactly?
so that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you.
Okay, I'm waiting to see if they say anything else. We can talk about what we just heard and what that was all about. He's going to try
Whatever
again.
happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of trial. But that part of it, again, these are certain things I cannot assist with. And the Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give?
Yes, sir.
If you can just stand in front of the court reporter instead of taking the.
Okay, I want to go ahead and stop it just for a second so we can talk a little bit about what happened so you won't be lost as we're going through this. So, okay, apparently the defense has a brand new witness not yet disclosed. And this would be someone from, this is an officer, I assume, a police officer, a sheriff's officer, or a correctional officer from the jail. And someone from the sheriff's office went to speak to that officer. And this officer who was going to speak to the defense and they were going to interview this officer suddenly now is saying they're no longer willing to speak with the defense. And so suddenly, and they're not going to be available. They're on leave or vacation or something. So, and let me write that down because that was an extra point. So this witness apparently was not disclosed to the state because it's a brand new witness for the defense. So here is the issue of all the players, okay? The defense is saying, here's someone who can help us, and the sheriff's office is actively intervening to prevent this person from speaking to us so that we can find out what information they have. That's wrong. It's the kind of thing we saw a lot of in the Karen Reed case, right? And we saw a lot of allegations from the defense that the prosecution and law enforcement were interfering and were trying to prevent information from coming out. We saw that with Detective Devers, you may remember. And then we saw those kinds of allegations, I mean, in the case of Detective Devers. But in this case, that's what the defense is saying. Now, the prosecution is saying, look, we don't know what you're talking about. We don't know who this person is. We haven't done anything. And so you aren't telling us anything. I don't know how to respond to this. They haven't really spoken yet, but that's what we've gathered. And the judge is saying, why is this happening in the middle of trial? This should have happened a long time ago. This is not something that should come up in the middle of trial. And you're asking me to force someone to come to the court when there's not even a subpoena for them. And you won't even agree with me that you do plan to subpoena them. You won't agree to that because of the fact that, and the defense says, well, yeah, we won't agree to that because we don't know what the person is going to say. And if it's going to be negative, we're not going to subpoena them to testify in our case. So everybody's going around in a circle about this. Now the judge is swearing in the sheriff's, someone from the sheriff's department who will supposedly talk about this.
If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened.
To my knowledge, I was approached by Captain Georgia Dent, who has spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Any examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is
And for those of you, it is super hard to hear this guy. He's not speaking into any microphone. So yeah, that's really hard. What he said so far is that we got Deputy Franklin is apparently who this involves. And she came to us and she said, the Adelson attorneys want to speak to me. Do I have to talk to them? And they round robined it. She went to Captain Dan. Captain Dan went to this guy who went to the council for the sheriff's department. And they determined, well, here's the deal. Deputy Franklin, if you want to talk to them, you're free to do that. If you don't want to talk to them, then they need to have a subpoena to force you to talk to them.
now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served.
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
So now the defense is saying what they had said earlier, which is their understanding is not only is she refusing to testify but she's now on leave and they can't serve her with the subpoena. And the sheriff's office is saying, well, that's not as far as I know. As far as I know, she's available to get a subpoena.
Sheriff Google, there is no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
So that's the sheriff. I couldn't understand the name. Goodwell, maybe?
Concerning the other witness, who is not the guard or the defense, able to make contact with this individual.
Just a moment, Your Honor.
This was not the
Judge,
law.
the information that we provided to Your Honor was purely to put it on the record that we had followed that information. After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were given.
Given the misinformation.
As to the, I believe, second witness.
Give me just
Hey everybody, Dr. G here.
dang it. Well, sorry, Dr. G. Let me back up just a little bit. I wanted to hear what they said again, but I hit the wrong button. Okay, so I really want to hear this. I'm sorry. All this for 5 seconds where I missed a word. This is what I do all day when I watch by myself. So aren't you glad? I've tried very hard to avoid that.
Yes, sir.
Okay. I'm going back to where we were, I hope.
After that, before the jurors are brought into the room.
Oh my gosh, not 3 weeks. Please. All right.
Was purely to put it on the record that we had followed that information. After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were given.
I still can't understand the misinformation.
As to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as part of the case?
No, Your Honor.
As to the guard, if you need to follow up with a subpoena for this individual, if they have chosen not to speak with you, do so with all haste. The jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon,
This afternoon is up in the air, and that's going to require some additional conversations with the client.
during the lunch break, that would be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it'll be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Today's the day.
Please bring in the jurors.
Your Honor, I know that 3 of the witnesses are here. Ms. Descalzo's flight does not arrive until a little after
10 o'clock, so
Yes, sir.
Okay. So, all right, let's talk about what's just happened. Meanwhile, oh, no, they're still going to talk.
neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
Yeah, the prosecution's going to say, nope, don't have anything to say. You ruled for us more or less, and then the defense withdrew it. So why would I say anything? That would be crazy. Huge mistake lawyers make is talk when they've already won. Shut up. If you won, don't say a word one. Just go ahead and be quiet. Okay. We'll go ahead and we're going to stop it right there. So to finish up, kind of wrap up, the defense said they wanted to put it on the record, but then they also put on the record that they're not going to pursue this person. So it's no good for appeal if it isn't something that you tried to push and then lost. If that doesn't happen, you can't use it on appeal. So this is not going to help them. As far as why they weren't going to use it, why they weren't going to use this witness, they said it was the status of the individual and misinformation. And then I was unable to hear what he said at the end of that. It sounds to me, their point was they heard this person, this is totally guessing, putting it in the context in this case. They heard about Deputy Franklin, and maybe she would have some information about those 2 jailhouse informants against Donna Adelson. Remember, we've heard from Patricia Bird and we heard from Drina Bernhardt. Both of them said that Donna was trying to get them to lie, trying to get them to make up this story that Katie Madbanowa had confessed in prison, that she had confessed this whole thing was just a setup of the Adelsons. She and her friends did this all on their own and did it to try to extort money from the Adelsons. They did the murder, but they didn't do it at the request of the Adelsons. They did this to extort the Adelsons. So that's what they were supposed to say. Instead, they turned that information over to the state and they came in and testified that Donna was pushing them to lie. So that's what this is all about. And Deputy Franklin must have had some kind of information. They heard that she may have, who knows, talked to one of the prisoners, had some information that they really were lying, or maybe that they got a deal. Who knows what it was. But the bottom line is the defense, after pushing this and putting it on the record, then said, we're not going to pursue it. It said due to the status of the individual, which is the individual supposedly was on leave and not available to be served. But we specifically heard from the sheriff that wasn't his understanding. As far as he knew, she was not on leave and available to be served. So that appeal argument is gone, and some kind of misinformation. So it sounds to me like their concern is that Donna Adelson would not necessarily be helped by this. That this person is not wanting to talk to them, is hostile. They don't even know if the person has information, so they're not going to pursue it. That's what it sounds like to me, meaning it cannot help them on an appeal. So it's not going to be useful to them. So they've now gone through the list of people they're likely to call this morning. One of them is Marisol Descalzo. That was Donna Adelson's first attorney, even before Daniel Rashbaum. She appeared with Donna when she was first arrested. So this might be someone involved in the decision about going to Vietnam. This might be the person who talked to the state attorney's office. But in any event, her plane arrives at 10. So the court has mentioned again, we've told the jury 3 weeks. So we need to really stick to our 3-week schedule. Now, they're not anywhere really near 3 weeks at this point. If you count jury selection, okay, yeah, they're kind of coming toward 3 weeks. But if you don't count jury selection and there have been 2 days off, not really. They were now on day 8. So they're in the middle of week 2. So I don't know how he pitched it when he talked to the jurors about how much time they would be out, but he's pushing them on that. And he's suggesting that the defense has a huge decision to make today. And that decision is Donna Adelson going to testify? They're going to make that decision over lunch, meaning I think we're going to hear from Donna Adelson today if we're going to hear from Donna Adelson. So they're planning to make that decision over lunch. It sounds like this could be the wrap up of the defense side, except for the issue of Donna, but we will find out.
Good morning, members of the jury. Good morning. Everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. Defense will call Kristen Adamson.
I strongly agree with them calling witnesses. I just think it looks terrible when someone doesn't even call witnesses. Like, okay, I'm sure we're all fine. That just, I don't think anyone buys that. We'll skip through this part while Kristen Adamson comes in. So we won't miss any testimony, but we will make up our time. We're about 4 minutes behind.
Today will be the truth. You may take your seat. You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
And Ms. Addison, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again, where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
In your work as a family law attorney, did you have occasion to represent Wendi Adelson?
There we
I
go.
did represent Wendi Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not
Interesting.
how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that. And that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now, that are not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to being close to my parents. It's a very common thing for people to want to move to be near their parents, no matter how old they are.
Now, do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes a little bit more, sometimes less.
Did you have that conversation with Wendi Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her. This was her one shot at it. If you get divorced and then try to relocate afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
So in other words, is it not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Now, the standard for a modification, what is that?
Standard for a modification is a substantial change in circumstance. And at the time that I had Wendi's case, there was also another component which no longer exists. But at the time that I had Wendi's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. The detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendi Adelson, if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school. Children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
So, quick overview. This was Wendi Adelson's lawyer during the divorce proceedings with Dan Markel. And what she's doing essentially is telling the jury that what Wendi went through was extremely normal. This was not an unusually bitter case. She said she would not call it a bitter custody battle. Instead, this is very typical. The court, people will ask for relocation. You have to ask for it on the front end. It's not normal to get it. She said at best it would be 50-50. There's a presumption against it, which would not be 50-50, but anyway. And so she told Wendi that, and that her one shot was to do it during the divorce proceedings.
Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
That's not 50-50.
So would you say it's difficult?
I think it's difficult.
Now, even though you've only gotten court approval for one with the client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendi.
I did.
Was she aware that the chances of success were low?
Yes. I mean, I told her that this was her shot. I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it for many reasons. But including the fact that her parents were down there, that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Now, let's talk about family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on that financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits. And I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
So just to give you a little preview of where she's headed, I believe this is Wendi's first attorney, and this is the attorney who ended up recusing herself from the case over an issue about the financial documents and whether they had all been produced. You may remember there was a motion by Dan Markel to have Wendi held in, I think he wanted contempt. I don't remember exactly what he was asking for, saying she had not disclosed everything. So if you're kind of wondering where we're headed, I think that's where we're going with
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendi's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it after, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that 100,000 theoretically, except for 2009, that $100,000 continues to grow. So you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Now, I want to back up a little bit. What happened with Wendi Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendi Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that. And then at the end of our testimony, the judge asked to speak to counsel, which happens a lot. And she took counsel out. It was me and Professor Markel's lawyer. And she told us she understood why Ms. Adelson wanted to move. But she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after
I want to stop for just a second. NK is asking a really good question. How is she allowed to talk about all of this? Isn't this attorney-client privilege? And that's a great question because, of course, we all know that you aren't allowed to talk. Thank you, NK, for your question. That an attorney is not allowed to disclose communications between the client and the attorney. And I think that's where the distinction is being made here. She's talking about what happened in the case. She's talking about overall what was filed, what the dispute was, as opposed to anything that Wendi told her. That's a really good question, and I appreciated that. So essentially, we're getting up to the point Wendi is being told by the judge she's not going to win relocation. And we know from what the defense has argued earlier that they're suggesting Wendi didn't ever tell Donna about this. Wendi agreed that there would be no relocation. She wrote that in the agreement she made with Dan Markel at the end of this hearing, but she never told her mother that. So her mother kept thinking it's still an option. And in fact, it wasn't. This was the one and only, and she lost.
the judge made those comments, did Wendi go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendi about that, and then Wendi's parents were there, and I actually spoke to Wendi and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendi ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013.
Yes.
And what was Wendi's reaction?
At that point in time, I think she was upset that she wasn't going to be, I mean, nobody wants to not win their case. She was upset. She was always calm. during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendi Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past
Now,
and since that time as well.
subsequent,
Let's do a quick little recap. So what's happening here, Wendi is saying, the judge tells Dan Markel's counsel and Wendy's counsel, I'm not going to go with the relocation. I'm not doing that. And so at that point, they reach an agreement, and Wendi tells her parents about this outside. So she can't say what Wendi told her parents. So the defense is free to say whatever they would like about what happened there. The judge, at that point, they negotiated visitation. The relocation was denied. She didn't win that. Wendi didn't seem particularly worried about it. She seemed pretty calm and resigned about it. She wasn't happy. But there was still nothing wrong with offering what the prosecution has called the $1 million bribe to Dan Markel. They could still offer him compensation to change his mind. It wasn't that he couldn't change his mind. He couldn't agree to something else. It's just the court wasn't going to force something else.
to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time, but we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
And before we had a court hearing trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion. And then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions, you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd, he is not with us anymore. And Professor Markel is not with us anymore. So a lot of people in that mediation are gone. And
So let's talk for a minute. What she just did, she put the judge on the spot. She basically said to the jury, hey, I would really like to be ordered. And she turned and looked at the judge. I would really like to be ordered to say this. Here's the problem. She is the only person who's going to testify to what happened in the mediation. The people who were on the other side, as she just said, are both dead. That's pretty unfair, right? It's going to be a pretty one-sided account of what happened in the mediation. Now, she's absolutely right. The point of making a mediation confidential, and I am a mediator now, I help people resolve their cases without having to go to trial. Based on years of going to trial, I know exactly kind of what the factors are that will make people think about that. And so that's how I help them. But as far as the point of mediation being confidential, the reason that we do that is so that everybody will just come in and talk without worrying about having to always maintain their position. They can say, well, okay, yeah, this argument is a little weak, but I think it's a good argument as far as appeal. Or they can just be honest about their positions, and it's not just about the money. It's also about the stances people take, because you would like people to be able to say, yeah, I am worried about that argument. I'm not sure I can win that one. You want them thinking that way. Honestly, you usually separate the parties in order to facilitate that, because when you get everybody in the same room, it's just nearly impossible for them to do that. But so her view of the mediation is going to be her room, her side. Most of the mediation, they probably were separate. So I don't know. I would have serious problems with this if I were the judge.
Ms. Adelson has waived confidentiality.
Okay, so Ms. Adelson has waived confidentiality. So that explains the answer to the question that was asked earlier about how is she able to talk about this. Wendi said it was okay.
With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The
Interesting.
state may cross-examine as to all subjects as well.
Okay, he's ordering her to
Thank you very much, Your
testify.
Ms. Adamson, can you tell us that
This is
Charles
interesting.
Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last minute little dust up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined in his opinion what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then then he went into the other room. We're not in the same room. We're in, Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after
So
that,
do you see what I'm talking about? They're in different rooms. So her account of what happens at the mediation is based on the room that she's in and what she's seeing. I have a problem with this. I have a problem with someone explaining what happened at mediation when you can't have the other side and they're only seeing half of what's happening at most.
mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement. And Professor Markel had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had non-marital money as well.
So based on what you've discussed, Mr. Markel was aware of the non-marital status of that portion of Wendi Adelson's portion of what she would get.
He was.
So that's helpful to Wendi, by the way. This is a not throwing Wendi under the bus issue. This is a getting Wendi's point of view out, which is Dan Markel knew perfectly well that she had non-marital money, and everyone was pretty much agreed with that. And in fact, Dan Markel had non-marital money too. So it wasn't like Wendi was hiding something, and therefore extremely unlikely that the motion we've heard about from the prosecution would ever result in some kind of bar complaint or disbarment for her.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendi invite you to a get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendi Gets Her Groove Back. And I had several friends I knew of Wendi's that were there as well. And it was just sort of a, Wendi's in a good place, come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
That includes costs and everything, I think.
Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, we had, I don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, did the marital settlement agreement require that Mr. Markel pay Wendi and yourself certain sums?
So according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendi for her part of the house. And all the other assets were divided equally so that he kept, he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendi did. And it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendi did. So that was part of the agreement. He was supposed to pay me $10,000. He was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st.
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendi, the money. He gave her $50,000 of the 120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did Wendi ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he's owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier. People will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Did that prompt Mr. Markel to pay?
No, it did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, this first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached and he shouldn't have to pay her the money.
So he filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendi at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was
I do feel that.
voluminous, and it was very personal about what was going on and Wendi and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically, if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
You filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
Okay, so the interpretive dance on this, for those of you who are like, what is she talking about? She's going into the details about what actually happened in the aftermath of what was supposed to be a settlement between Wendi and Dan. Everything's supposed to be over and done. They've agreed on everything. They've been at the mediation. They figured out these Charles Schwab accounts. They've split them up. There's this non-marital, there's this marital asset. They've got it all figured out, and they reach an agreement. Well, what part of the agreement that they reached was Dan Markel was supposed to pay $120,000 to Wendi, and he was supposed to pay $10,000 to this attorney, Wendi's attorney. And he never paid those. And they tried and they tried and they tried to make him pay, he wouldn't pay. So finally, they filed a motion saying, you got to pay. Why have you not paid? And in the response, Markel got a new lawyer, and she says she thinks Markel was writing these motions on his own because they seem pretty far outside what a normal matrimonial attorney would do. It didn't make a lot of sense to her. But essentially, he said, well, I shouldn't have to pay the 120 and the 10, which we agreed to in the mediation, because it turns out you, Wendi, hid some assets. So since you hid some assets, I shouldn't be forced to pay this other amount. We should be able to offset those or figure it out somehow. And so she's saying a couple of things. One, no assets were hidden. This was all discussed in the mediation. He already knew about that. And number two, that isn't the way the law works, where you get to just not pay something you were ordered to pay because you think someone owes you other money. You've got to get an order saying that there's just a different process. So she is now at this stage in her story that she's telling, she's moved to dismiss it. And I think that's about where it's going to end.
The process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendi's part?
I think he filed at least one or two more pleadings that did that.
And before we get to the final one, that you advised Miss Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendi that it wasn't, and not to worry about it.
Now, there was a hearing.
Let me see if I can
in
fix that in
February
case
of
I'm pixelating for you.
2019.
Give me just a second. Let's
I think
stop this so we don't miss anything that's said. I tried to change the settings on this while I was live. I suppose I'm going to try adding it. I don't know what I've done. Let's see. What could I do that would maybe fix this? Because dang, I'm going to get dizzy. Let's see what I could do. I could go to settings. I'm going to switch to this. And then I'm going to switch back. And we'll see if it's better. Thank goodness. That was making me really dizzy. Okay. Sorry about that. I will no longer try to change settings while live. Clearly not a good plan.
Records indicate that that Mr. Markel and his attorney were attempting to depose Ms. Adelson.
So what happened was, I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing. The judge read all of the pleadings and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting. And it was that Wendi wasn't allowing him to FaceTime with his children as much as he wanted to, that they weren't allowed to go to be present at the same birthday parties, that if there was a birthday party that he was at, she wouldn't come, things like that. And that she wasn't, I think there was a right of first refusal and that she was letting her mom watch the kids, and he didn't like her mom watching the kids. And I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time.
So breaking in again, essentially what she's saying is Dan misbehaved. Dan did bad things in the course. Everything seemed to be kind of working out when they initially did the divorce, when they initially set up the custody, and things deteriorated afterwards. She believes it's due to Dan Markel. He didn't pay the money he was supposed to. He filed ridiculous motions, which even the judge disapproved of, and that he then began to bring up parenting issues, more like he was just being a thorn in the side of Wendi. So that's what she's presenting. We're not going to hear anything counter to this because apparently Dan Markel's attorney at the time of the initial part is deceased. I don't know about his attorney at this stage. I think we heard from his attorney at the last trial, so maybe he will testify on behalf of the state. But Dan Markel is not here to testify. So we're getting, realize this up front, we're getting one side of the story.
He also, I think it was that pleading where he went on a little bit more about Wendi and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Now, the one motion concerning his, my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already done they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they become completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No, it's not possible. And I told Wendi that.
Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendi.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendi Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't, even after even afterwards, I didn't, they were fine. I had no issues with them, but I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Just a moment, Your Honor.
That was a point that the defense made earlier, that Wendi came out and relayed what had happened, not that Donna heard it firsthand, which is why Wendi was able to tell her the judge ruled against us, as opposed to I agree. So let's go ahead and stop for just a minute. How far back are we? Oh, goodness, we're a long way back. I may speed it up to 1.25, which is very hearable, especially on kind of a slow cross like this. So, but let's talk a little bit about why this matters, because I hear some people, see some people in the chat saying, you know, why do we care? Why do we care about any of this? Well, the state has made a point about this dispute between Dan Markel and wanting Donna not to be allowed to see the kids. And they've said this is a huge motivation. Donna, as you know, was the state's theory is she was fixated on moving the kids down south. They weren't allowing her to do that. Dan Markel was standing in the way of that. He'd even gone so far as to file a grandma motion to keep her from unsupervised visitation with the kids. Now, we've heard from the defense that's not what the motion was about at all, that it was about parental alienation done by Donna, and that this, what the attorney has told Wendi is nothing's gonna happen from this. This is a ridiculous motion. She is implying Dan went kind of nuts after the divorce and started filing a bunch of motions that really made no sense and was losing them all and was going to continue to lose them all, that he was making absurd claims. He was trying to get out of paying money. So that's sort of what the theory here is that the whole idea of the state that Donna is this crazy over-involved parent doesn't make sense. She's not really involved in the divorce at all. And the idea that she is going to lose her right to visit with the children, that's also ridiculous and not going to happen. So now we're going to hear the cross-examination on this.
So you said you weren't aware of Donna Adelson's involvement.
She was not involved with me.
Okay.
I don't know.
Did you know that she was drafting Wendi's filings and having Wendi copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendi to put in her filings in Wendi's voice?
Not that I'm aware of.
Okay. Did Wendi, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendi on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, you know, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendi sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendi.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that
Well,
time.
I'm always hopeful, you know, but,
Right.
and I thought she had a good shot or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes,
Okay. Even given your best guidance?
yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right. And at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
You know, I've been trying to think about that. I think that that's probably why I had them sit outside, is because they
Right.
could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So
and-
that's right. Yeah.
Okay. So that's why they were in the hallway.
That's why
most
they're in the
likely.
hallway. Yeah.
Okay. Not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. Did their thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. If they do.
Okay. And you said Wendi was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendi Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure
court.
you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendi, and then briefly, as far as I remember, because I mean, it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, you know, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendi went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate,
Okay.
which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
No.
Okay.
I don't remember any about her being
about
unhappy.
Dan Markel.
I don't remember any about her being unhappy with the representation. I don't remember her saying your attorney didn't try, your attorney didn't do well. Anyway.
Not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact of that he was accusing Wendi of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue. And that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying. And then,
could I ask you a different question? I'm
okay.
sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step. It would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequences, we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money. And then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly? If he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet,
Okay.
but they could. It is a possibility.
Did you inform Wendi Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did, because it's kind of a generalized form. It's a motion for contempt and enforcement.
And then at some point, did he allege that Wendi Adelson should be held in contempt?
I don't know if contempt, I don't know if, I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendi should be disbarred. I
Okay.
mean, that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine. And then all of a sudden he decided not to pay the rest. And I didn't really get it and know why he was doing that because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendi or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious is when he did that.
Was that personal attacks on both Wendi Adelson and you?
Correct.
And he was alleging that Wendi Adelson committed fraud, right?
Yes.
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendi Adelson's behalf, right?
Correct. That's happened before though. I mean, I've had that happen before.
And he alleged Wendi should be disbarred, you said.
Correct.
And he's having issues with Wendy's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markel and Wendi Adelson continue?
Oh,
even
hold
after-
on, wait a minute. That sounds like a hybrid between what the two sides are saying. The prosecution is saying Donna was not going to be allowed to have unsupervised visitation. And the defense is saying all this was Donna wasn't supposed to get the first right to see the kids if Wendi was going to get a babysitter. First choice for babysitter was Dan Markel because he was the dad. Second choice would be Donna, and then on down the line would be hiring somebody. So, and this is sort of like a combination of that. If there was a right of first refusal, then she should not be allowed. So who knows exactly where it is? I don't think we have a clear answer.
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendi Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not, we've had a few people get murdered, and I've had a few suicides, but it's rare, and I remember all of them.
Right, but not contentious.
Sometimes, I don't know with the suicides, I don't know. Thank you.
Redirect examination.
Briefly, Your Honor.
Uh, 454.
Sure, okay.
Is that the March 26, 2014 pleading that Mr. Markel filed?
It appears to be,
Turn to 454 that I attached.
yes,
Is that the prayer for relief for that motion?
yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's time with the children? Does that reflect that Mr. Markel was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children, consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Okay. I agree with the defense then. That's more on the side of the defense and the way it's been characterized as a prosecution. It doesn't say Donna should not have any unsupervised time with the kids. It says the unsupervised time should not interfere with his right of first refusal, and there should be limitations that prevent her from disparaging Dan Markel. That has been a very confusing issue throughout this case. It's been hard to tell what the meaning of all that was. Now, of course, all that is a way of characterizing how it is that Donna is being prevented from seeing the kids. It doesn't mean that she's getting unfettered access. She's going to get less. If Wendi is going out at night, she's supposed to offer the kids to Dan Markel instead of saying, hey, Mom, I'm going out on Saturday. You want to come up and take care of the kids? So it's still less time for Donna. But the way it's described is maybe a little different.
You testified that the divorce was not contentious, but some of his pleadings post-divorce were contentious,
I think that's accurate.
and that his pleadings were personal. He essentially he attacked both Wendi Adelson and yourself.
Correct.
Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markel not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, after, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling to you.
As far as I know,
You don't know what she said privately, do you?
I do not.
Concerning Wendi Adelson's involvement in drafting of pleadings, I've understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I don't take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you.
Well, and sometimes if they send me really good facts, I'll sort of, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendi Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendi, I don't remember that Wendi had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of ChatGPT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am. Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay.
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further.
Will this witness be recalled?
We'll retain her, but she's free to go about her business.
Thank you.
You may step down.
Okay, let's have a quick talk now. Why did that part at the end matter when she said the only reason she withdrew was she was going to be a witness? And then he said, okay, if Dan Markel hadn't filed those motions, then would you have gone forward with that hearing in May? Well, the state has argued that the Adelson side was very worried about that upcoming hearing because it was the one where the court would decide whether Donna would be allowed unsupervised visitation with her kids, and that she was being accused by Dan Markel of trying to alienate their affections. In other words, try to keep them from loving their own dad by saying negative things about him. And what the defense is trying to give us a very different view of everything that happened. That the problem in the litigation wasn't Donna, it wasn't Wendi, it was Dan Markel. That Dan Markel was the one who was contentious. He was the one filing really absurd, out the wall pleadings. He was the one attacking the Adelsons. And even so, he wasn't actually asking that Donna not be allowed unsupervised visitation. That wasn't even his request, even though that's what the state is telling you. This is what the defense is saying. But that it, ironically, this hearing that supposedly the Adelsons were so afraid of, it would have happened in May had it not been for all the extra attacks he did on the attorney herself. It finally reached the point where she said, I'm going to have to be a witness. I'm going to have to pull out the case so I can testify because I can't both be the attorney and testify. And when she withdrew, she had to get in another lawyer. It took time for him to get up to speed. So that May hearing got put off. The only reason it got put off was Dan Markel, not the Adelsons. So what the defense is trying to do is to upend our understanding around what happened with the divorce, and even more importantly, the follow-up, the custody issues that followed the divorce. The divorce itself, she said, not that contentious, kind of average. It was after that when Dan Markel went off the wall, began filing these really intense pleadings. And these pleadings were what created the trouble, and they were wildly inappropriate. He was the one who was the problem. This is the significant part about this is that the defense is trying to change a storyline, a prosecution argument that we have seen as a theme. We saw it in Charlie's case. We see it again in this case, and they're going directly at that theme, trying to say everything you think, you, the internet, you, the world, you, the jury, may think you're being told about this divorce is incorrect. You're seeing it as something problematic for what the Adelsons have done, and you're being told something incorrect. This is really a Dan Markel problem, which is interesting because up until now, they have frequently aligned themselves with the Markel side, right? We heard from the beginning about this noble man, Dan Markel, and how great he was and how desperately terrible it was for the children to have lost this wonderful man as a father. And Donna was on the side of that. So here we see the opposite.
Please call your next witness.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break.
Do any of you need to take a break or use the restroom? Please raise your hand. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room.
Okay, so
Zoom
there.
10:05.
There's a witness who isn't there yet. And I figured they were going to have some problems this morning. I think they went through their witnesses a lot faster than they figured.
She does have some notes with her if she can't remember something.
That's fine.
What?
All right, please stretch your legs or use the restroom if you need to.
I'll try to.
She does have some notes with her if she can't remember something.
That's fine.
She has something in case you can't remember
Use the
something.
restroom if you need to. We'll try to start again at 10:05.
Thank you, Your Honor.
Okay, so I guess she's got notes and she's going to have them at the front. Let's see how far this goes so we can kind of catch up a little bit. And I see some really great questions over here in the super chat. I haven't forgotten you. I just want to have the time to answer those. So we'll do that probably around lunchtime. I appreciate the questions, and that'll give us some good stuff.
Whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday, determine when the topic of Linda Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but for review. At minimum, Ms. Kettleman, exclusion is always the most extreme remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey will review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know I'm going to go to the court reporter's office to check the sidebar. From there, we can finish this matter with the president.
So here's what it sounds like, that this witness, just like the witness yesterday, was actually in the courtroom during some of the testimony, which is not supposed to be happening. There's a rule of sequestration. That just happened with the defense witness yesterday. And last night before we left for the evening, the judge told the defense, don't let that happen again. And it sounds like it has happened yet again. So there was some discussion about that. Apparently at a sidebar, the judge is going to go look that up and then come back and give us more information about that. So we'll see if they have come back. They're still out. Okay, perfect. We've got time for our questions, and that worked really well. And I do have a poll I want to ask y'all a question about. I want to know the witness you most want to hear from. I'm going to give you 3 choices. There could be others too. We'll do these 3. Charlie Adelson, Donna Adelson, and Harvey Adelson. And we've already heard from Wendi. And I'm wanting to know if the witness you most want to hear from in this trial is, and fill in the blank, okay? So there's your poll. Y'all can be answering that while I go look at the questions over here. Okay, Brooke asked me a question about the attorney for Donna Adelson, one of the 2, Jackie Fulford, and that at one point she was packing up and had her back turned while the judge was speaking. Is that normal in a courtroom? Is that how people behave? Is that etiquette in the courtroom? Brooke asked. And I didn't specifically see that, so I can't really answer that. I don't know if maybe the judge was talking and she turned to put something in a book bag and turned right around. I don't really know. Typically, this is kind of my view of it. When you are in the courtroom, your goal is to represent your client, and that involves persuading other people who will be making the decisions. One of the hard things about being an attorney is you don't get to make any of the decisions, right? You get to try to persuade the judge or the jury to make the decisions. So your goal is constantly to be thinking about, how can I represent my client to this judge, to this jury? How do I put on the best possible case to persuade the person who does get to make the decision, or the people who get to make the decision? So I think generally the rule is you want to treat the judge with ultimate deference. You want the judge to think very highly of you because that's who you're trying to influence. That's where you are representing your client. And then the same would be true with the jury, to the extent you're trying to influence or represent your client to the jury. So in general, you at all times want to be completely deferential and show great respect to anyone in authority. I haven't in general seen any suggestion that Jackie Fulford did not do that. I don't know about this particular thing that happened. It may just have been a small thing. In general, I think all the attorneys have been extremely appropriate in the courtroom, but that's just my general thoughts on courtroom etiquette. And Neil Morrison, Bill Slim's fan club, I should say, has a question. Do lawyers prepare their clients in body language? Because it doesn't look like it in Donna's case. The Scottish expression, suckling a sour plum, springs to mind. So I don't think there's a great way to prepare a client for body language. It's such a natural, inherent part of how we act. There are a few things you can do that the person may be able to remember for a brief period until their mind slips and they revert back to what their normal means of communication in terms of body language would be. So you can tell someone, turn and look at the jury. You can tell someone, look straight at them. Don't cross your legs, don't cross your arms, speak to them directly. You can say things like that. And for a while, the person will remember, but they don't remember for very long. I think lawyers do tell them things like that. When try to look open, try to look like you're communicating and you want to get a point across to them, and look at them. Don't look away from them. But that can't go too far. Don't you remember the Amber Heard Johnny Depp trial where there was a big dispute about Amber Heard? With each question, she would turn with, mechanical precision to the jury, speak her answer and then turn back around and then turn. And it became kind of too much. It was unnatural at that point. So most people can't follow body language instructions like Amber Heard could. So I don't think it's that easy to do. I would say most lawyers don't even bother. I would say some do and have some limited success. For example, Donna's been told clearly by her attorneys, based on the change from her early appearances in court, don't make a lot of facial expressions. Don't react and she's very passive, isn't she? She's very little reaction. And if you take that back and compare to her first appearances in court, it's radically different. Pascaline, who's been watching the trial with us from Paris, is asking me about appeals in Paris, saying that you automatically get an appeal trial, not just an appeal, but a trial. And in the US, appeal seems to be an issue at any time during the first trial. So Pascaline, the way we work it here, I believe in France that you typically have a trial with just the judges and not with a jury. We have a trial with a jury. From that point on, it's going to be just the judges unless they order a new trial. So all throughout the trial with the jury, all throughout the preparation until you get to the trial with the jury, you're constantly thinking about what are the appeal issues, what are the things that I would need to raise for my client where I'm losing an argument down here, but I think the appellate court might rule with me. That's something you think about during the entire trial. When the trial ends and the jury reaches a verdict, you then go up on appeal, and the appeal is just judges, and you have, in general, you will have the ability to appeal at least once. The appellate court doesn't have to do anything with your appeal. They can just say denied. They don't have to do anything, and they very particularly don't ever hold a trial. All they do is look at what happened in the trial and decide if anything unfair happened. If they conclude that there's some reason why you get a new trial, they send it back down to the first court and you get another trial again with a jury. But you don't ever get a trial in the appellate court. I want to welcome Randa and Dean, who are new members. We are delighted to have you. And I'm checking over here to make sure I don't miss, the court coming back. So I will put that right there. All right. And thank you, Randa. I appreciate that. Saying, although we all agree Donna is guilty, I appreciate your advocacy for a strong defense. I just think our system works better like that. I also think it gives us confidence that the system is working. If both sides have presented their very best case and the jury still says, yeah, clearly guilty, then we know we've done our part to preserve the rights of Americans, of this particular American. We know that we've done that. And I think that's critically important. So I appreciate your saying that very much. Paul is a new member. Welcome, Paul. Glad to have you. Glad to have Dean and Randa. We got a bunch of new members. Delighted to have all of you. And Paul, also brand new, already participating with the Super Sicker. Thank you, Paul. I appreciate that very much. All right. So I've now answered our questions over there. They are still out on their short break as the judge considers what he's going to do. He's going back to look at something that was a discussion about Linda Bailey. And his understanding was he thought Linda Bailey was permitted to be in the courtroom. She was going to be allowed to do that. And he also warned the prosecutor. He said, exclusion is disfavored, meaning in general, I'm not supposed to keep out a witness just because they saw something. Only if there would really be a problem am I supposed to do that. And so I think that Linda Bailey is going to testify. The question is kind of what he's going to come back with as far as whether she was permitted to be in the courtroom. But it sounded like he's very inclined to let her testify, but then to allow the prosecution to say, well, isn't it true you were sitting here during the testimony of blah, blah, and blah, and you might have been influenced by that. He's going to allow her to ask that question, but he's going to let Linda Bailey testify. That was what he was leaning towards. He is going to check that record and see if he's right that it was even agreed to in advance. She could be there, in which case there's not even an issue. So he'll be coming back with that answer, I assume, in just a minute. They've had a little trouble with their witnesses. We knew that Marisol Descalzo was coming in on a flight that arrived at 10, which means she may not be here right at 10, and she may not be at the courthouse 20, 30 minutes later. It may take a lot longer than that. And then also now Linda Bailey apparently was a little bit late, they were saying. So, but she was there. We saw her standing next to the defense attorney. So she'd seem to be there. I don't really see that there was some huge problem with that. Oh, let me go over here and see what your vote has been to see who you wanted. Oh, y'all are split. You are not sure. Oh, you're not really split as I open it up. Okay, how many do we? Oh gosh, we got a lot of votes. Y'all are all in on this vote. Everyone wants to have an opinion on this. So, okay, we're going to do our first poll of the day was the witness you most want to hear from is, and your choices were Charlie or Donna or Harvey. And we've already heard from Wendi, so she wasn't in the poll. So that one didn't count. Everybody is always interested in hearing from Wendi, but we already did. So we didn't count that. I will let everybody vote. Oh, we're already, that's a lot of votes. Y'all are in on this one. You know, all morning, I don't think I've even asked you, would you please hit the like button and subscribe? If you're not subscribed, we would love to have you follow us here on the channel and participate. We are enjoying covering trials. It's really a lot of fun. Okay, I'm about to end the poll, although y'all are voting fast. I don't like to end it when everybody's voting because I feel like I'm preventing you from expressing your opinion. So let's, and then I have another couple of questions for you. All right, I'm about to end it. Go ahead, lock in those votes super quick. Okay, I'm ending it. And let's see what your vote is. All right. 58% of you want to hear from Donna Adelson. 29% most want to hear from Charlie, and 12% want to hear from Harvey. Probably all of you would say I'd like to hear from all three, but for as far as the most you want to hear from. Now, I'm going to ask you a question. Are we back?
Hot from the presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Please make your argument.
Okay, so he's got the transcript.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now.
Judge,
Why should this witness be permitted to testify, Mr. Zellman?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
I think he needs to let this in. They do not want to pull a witness on
With respect to
Donna.
the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened though is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized.
There you go.
previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has
Mhm.
been
That's why he's mad.
appropriately in violation of the rule of sequestration. When this was addressed at sidebar, he brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual, or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
Whoa.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy. But you did admonish the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So,
As to your point of the state needing a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't need to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may,
Last word.
reviewing Earhart, exclusion of the witness. Court may exclude witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This
Absent,
is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so a proffer can be taken on this matter. After that, I will step down, briefly review what I need and make a ruling.
Okay, so again, the interpretive dance. So what's happened here is there's a witness. I think her last name is Bailey, Linda Bailey, but it could have been Baylor. And she was apparently in the courtroom listening during the testimony we just heard from the attorney who had represented Wendi Adelson. She should not have been. Apparently last week this was argued, and the what was discussed was whether or not experts could listen to the testimony of other experts, and it was ruled on. And the defense wanted that experts could be able to listen to anybody, any expert, but the way it was ultimately ruled on was an expert for the defense could listen to the testimony of an expert for the prosecution, and vice versa, so they could respond to each other, but not that experts could listen to each other. And So an expert for the defense couldn't listen to another expert for the defense. At least I think that's what they're saying. And so that was what the ruling was. Yet despite that, this witness came in the courtroom and heard the testimony of the prior witness, Kristen Adamson, who had represented Wendi Adelson as an attorney. So the judge is trying to decide, does he completely exclude this witness so this witness doesn't testify at all? Or does he let this witness testify? And the rulings in the Supreme Court there in Florida are that it's real hard to literally exclude a witness. You don't want to do that very often. You do not want to have that happen on a regular basis because it might prevent a defendant from presenting their case. So the judge is trying to figure out what to do. They're going to have a proffer where they're going to talk about this very issue and this issue about this particular witness having heard it. So that's what we're about to hear.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of
And one other point, I'm not clear because at one point I thought the judge said that Kristen Adamson was not an expert. She was testifying as a fact witness to what happened in Wendi's trial. So that definitely would have been excluded under the court rule. So the state is pushing for complete exclusion of this witness. I would strongly recommend against that. The state is doing great. The state has presented a very thorough case. And why would you embed a potential appellate issue by totally excluding an expert? It seems risky to me. The judge, though, is at least giving it thought because this is the second time in 2 days that the defense has violated the rule that witnesses aren't supposed to be listening to each other, the exclusionary rule.
preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple of weeks ago, just to confirm what I supposed were facts. And I have known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markel's motions. And she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendi Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendi Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendi as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did,
And why was that?
just to confirm that I had the facts correct,
Okay.
and I did.
And you sat this morning through Miss Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Miss Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Compliment, an examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your
No, I don't.
preparations?
Think so.
No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes.
All right. So the court is in recess while the judge considers this and thinks about what he's going to do here. All right. So what's happening? Yesterday, the defense violated the rule of sequestration. And what does that mean? That one witness is supposed to be excluded while other witnesses are testifying. The reason for that is you don't want one witness listening to someone else's testimony and going, so that's what I need to say. Okay, I better make sure my testimony fits with them. If people contradict, you want to know that. And so witnesses, when the rule is invoked, they can't sit in on the testimony of other witnesses. So last week, there was apparently an argument over this very issue. And Linda Bailey had asked, she said, to sit in on the testimony of Kristen Adamson. She's the witness we just heard. She's a witness that represented Wendi Adelson in her divorce against Dan Markel, right up until she had to quit and let another attorney take over because she might be a witness. So the point is that Kristen Adamson was testifying, and this witness heard Kristen Adams. At the hearing last week, from what the judge says, apparently he agreed that it was okay for one expert to hear the other side's experts so they would know what they were responding to. But he did not agree that one expert could listen to either testimony by witnesses who aren't experts or testimony of experts who are testifying for the same side. So if the defense has two experts, they can't listen to what the other says. They can't coordinate that way. They have to just come in and testify to what they think. And they can't listen to all the other witnesses. They have to just come in and testify to what they think. They aren't allowed to shape their testimony. The only thing they can do is listen to the corresponding expert for the other side, and they can figure out if they disagree with anything that person said. So that was the court's ruling. That isn't what happened. Apparently, this witness actually did listen to the testimony that we just heard by Wendi's lawyer. She wasn't supposed to. That was not in accordance with the way the court had ruled. So the court is trying to figure out what to do here. It's disfavored to exclude a witness. In other words, appellate courts don't like it if you keep a defendant or either side from presenting their witnesses. And the obvious reason for that is the jury knows less of the facts. They know less of the truth or less of the expert opinion. You want the jury to have full information. So you don't want to exclude anybody if you can possibly help it. So the judges figure out, okay, what do I do here? Because you violated this not once, but twice. And yet here is this witness. So the questions that they just asked the witness were related to helping the judge make the decision about what to do. And the defense, essentially, she said, I listened to what was said and it just confirmed what I already believed. And the state said, did you learn anything new? And she said, no. I think the judge is likely to let her testify because I don't think it's going to be hugely damaging for the state. And I think it's something that could potentially pose a problem on appeal. So he's going to be, he is not going to know exactly what to do. He's upset. If it weren't that the appellate courts kind of frown on keeping out experts, I think he'd be, we are absolutely keeping her out, because I think he's upset that this happened not once but twice. And in particular disregard of his ruling that she wouldn't be allowed to see anyone except the other side's expert. So it's clear, because he actually had a ruling like that, I think it makes it less of an appellate issue if he chooses to exclude the witness. It means that fair warning was given and it was violated very specifically. So it probably would be safe for the state on appeal. Nonetheless, the side of caution would be to let the witness testify. And the witness can be asked by Georgia Kappelman, and I'm sure the defense would do it in advance to try to take the edge off the questioning, but they can ask, well, isn't it true that you now say this, but you sat in on the testimony of this other person, Kristen Adelson, so you could make sure you were the same. You wanted to make sure you tailored everything you said to just what she told you, didn't you? They can ask her that, and that I'm sure they will ask her that. But that's what this whole dispute is about. And we are now taking a little break while the judge figures out exactly how to handle that. So, Jeffrey, that is an answer to your question. This is what is going on. It's been a very strange morning. We started with the sheriff testifying. That was bizarre. And now we've moved on to the defense witness expert, maybe excluded because the defense expert sat in on the testimony. Very, very strange morning. And the defense seems to be having a hard time getting its steps together, getting its witnesses in order. This seems to be posing some problems for them. So thank you, Jeffrey. And there's your please explain. I want to thank Donna for her super sticker. Much appreciated. And okay, let's see. Do you have any questions over here? If you would put question marks at the beginning, that gives me a better shot of spotting what your questions are. So I will answer any of those that I spot until the court comes back and we find out what the judge will do. Yeah, Javon Cope says, these lawyers are bad for her. I would be losing my mind. Very unacceptable. There have been some missteps. It has to be really terrifying her, because there are some times, and to some extent, the attorneys can say, well, the judge is ruling against us, but some of these are really kind of things that they should have handled, like not communicating to this expert that she was not allowed in would have been critically important, especially because she had asked to be allowed in. So, or getting a clearer ruling that she was, and apparently they wanted that, but the judge didn't grant that, is what it sounds like. So that was a pretty specific ruling. Okay, I lost where I was with those question marks. Oh, here's Nick at NK with one. Do you think it was a mistake from the defense or blatant disregard? I think it was a mistake. I don't think there's any blatant disregard going on here. I have not at any point thought that. It seems like very clearly an error. And my guess is that having moved for this and having won part of it, they thought they won that she could see Kristen Adelson. So everybody thought they were good. And that wasn't really the way the court had ruled. Bex in Wonderland is asking me, what is the difference between a proffer and a voir dire? And it's spelled VOIRDIRE. And from the French, voir, see, dire, say. So, and a proffer is when you are going to make an offer to the court of evidence that would have been presented or that relates to one question he has to decide. So you're going to say, okay, here's the evidence around this piece. Now, that could be for this judge to decide or for the appellate court to know about, or both. Now, voir dire is when you ask a certain number of questions, usually in front of, or certain questions in front of the jury, sometimes in front of the court, but usually in front of the jury. And your point is to ask questions around the expertise of this person, or the or the foundation. Does this person really know what they're talking about? Do they actually have either skills or expertise here, or do they have a foundation for it? And you're allowed to ask that series of questions to establish that one point. And the point is really for the person making the decision, not just the court. So the proffer is when there's going to be a decision made around something, or even already has been, and you want to make sure the evidence is on the record. All right, I'm looking for, there we go. What is a proffer? Dan is asking that question as well. Why did the state not call Charlie? Asked Tricia. So here's my theory, Tricia, on that. Charlie is there as a rebuttal witness. What he is doing, I mean, he could be pretty damaging for the state, right? Because if, depending on what Donna's theory is and what she argues to the jury, he might back her up. And then you've got two people saying the same thing. So it's kind of 2 votes better than 1 in front of the jury. But I think they didn't call him because he's really there to keep Donna in check. As long as he's there, as long as he can be brought at some point, including in rebuttal, then she is pretty much locked in. Okay, let's see what the judge decides.
Concerning this issue of the testimony of Wendi Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand.
Sorry, let me re-mic myself. Okay, so the judge comes in and says, here's the test. The test is, was the testimony substantially affected by what the person heard that they weren't supposed to hear? So this witness heard the testimony of the prior witness she wasn't supposed to. And the judge said, I've looked at it, and she flat wasn't supposed to hear that. This is a second violation of the rule that was supposed to require that witnesses were excluded from the courtroom until they testified. They violated that. They did it twice, but the test is, was what the person was going to say substantially affected by what they heard, or did it have no impact on them at all? And this witness, he said, it's a lawyer, so I'm going to give her some credence as a member of the bar for truth in what she says. And she says it didn't make any difference. So it doesn't meet the test. I'm not going to exclude her testimony. But what I am going to do as a remedy for the state is I'm going to instruct the jury at the end of the case about how two witnesses testified in violation of the rule of sequestration that I had imposed. And so they're going to talk about what the language for that will be later.
If there are any additional matters that need to be clarified, this needs to occur so we don't have any more issues with witnesses or other problems. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adelson, so
Okay.
we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law. And what that requires is an application that's about 3/4 of an inch thick that details all of your trial practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, et cetera. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, Bailey.
Thank you. How many board certified family law attorneys are there in the state of Florida?
I believe there are about 274 according to the Florida Bar.
Okay. And do you know what percentage of lawyers in Florida are board certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education and continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
And they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
and judges also get that same peer review.
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course, you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education. It might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review. And the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests. Like, have you provided presentations? Have you taught? Have you done certain community service or pro bono work, that sort of thing?
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines. But at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
State wished to require the witness as to her training or experience. Any objection to her ability to provide an opinion in the fields of marital family law? Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Kind of a boring setup. All they're saying is she has qualification. She's an expert. State doesn't even object. She's now going to talk about family law to the jury. So now we're ready for her actual testimony in the case.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendi Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendi Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendi Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendi Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother. but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendi Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendi Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Now, can you tell you?
That's where it should have stopped. She should have talked to Adamson for an hour. They should have discussed what Adamson was going to say, what she thought, and then testified. She wanted to sit in on the testimony she made, and that's where the testimony she actually said to the jury, and that's where the problem came in that we've been addressing this morning.
Indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendi, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendi Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going. And it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendi Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel. Which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary. But then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendi Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing.
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now we're using the term time sharing. We also have during the trial heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
And so the term custody is not something that is used in family law proceedings any longer.
Not between parents. There's some the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendi Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So in other words, when Wendi initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law,
What I find really interesting about this is the way that they are supporting Wendi, when earlier we saw the opposite happening. I just find this really kind of fascinating.
pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation. And then he had filed a motion to enforce life as he would have liked to have seen it. And then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce.
So,
And then,
in other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendi's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document. So that was denied.
So he would, let me understand correctly, he was asking for court authorization to be able to go over to Wendi's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just changed their mind. So he was trying to enforce conversations that he had had with Wendi that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it. And he was basically saying that the petition for relocation was baseless and that the court should deny it. And the court said, no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendi essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did the
So in case you're wondering, I'll pop in when I hear anything that I think moves the case forward, but I'm not really hearing that yet. So far, we've got that Wendi wasn't pushing for some kind of substandard time sharing. She was agreeing that Dan Markel could have substantial time sharing. Dan was trying to enforce some ridiculous things he didn't have the right to enforce. And Wendi agreed to the denial of relocation, which actually was her giving up something because she could have appealed. But now she couldn't because she had breached this agreement. So there you have it.
did Wendi Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendi waived alimony. They adjudicated child support. They put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator.
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by, telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get him, her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson Markel case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce,
Yes,
up through July 31st?
yes.
No, they resolved everything: temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial. And
As of the final judgment of dissolution on January,
So what they're trying to convince us is that this was not a bitter or contentious divorce between Dan Markel and Wendi. It was kind of typical. Took about the same amount of time. Things only went off the rails later on.
July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
no, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly?
Yes.
During the underlying litigation, so between September 2012 and July 31st of 2013, when it was the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adelson spoke out earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery.
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendi about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days. And then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than finding him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company,
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. the difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140 something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendi Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, were, I believe, Wendi, was she deposed?
I don't recall seeing that Wendi or Mr. Markel were deposed.
Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
Before we get into Donna's involvement, which is obviously kind of a separate issue, I'm going to talk a little bit about, I see over in the chat some very valid questions about what does this have to do with the murder of Dan Markel? This seems kind of far afield, right? We're talking all this details about the divorce between Wendi and Dan. So, but kind of think of it, and I'm not going to defend this as fast-paced or exciting. I'm not going there, but think about it from the defense point of view. What they're trying to do is not prove who killed Dan Markel, just prove that what the state has said isn't enough to convict Donna Adelson, right? It isn't enough to establish that she's guilty beyond a reasonable doubt. That's their goal. So they're looking at some of the state's arguments and they're just trying to poke holes in them. So the state says, what's the motive? Donna really wanted this time with the grandkids. Dan was in the way. She was eager to get it. Dan was following these motions to prevent her from seeing the grandkids. That was the motive set out by the state. So the defense is not trying to prove who killed Dan Markel. They're just trying to prove Donna didn't have a lot of reason to be really furious with Dan Markel. Overall, it was a pretty easy divorce, as divorces go, and none of them are easy. Overall, there weren't a lot of discovery fights. No one was deposing. No one had deposed Donna. So there isn't this big motive that the state is claiming. So that's why she's putting this witness in.
No, we have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy, and full of hyperbole.
And that
More
same
pro
vein,
Wendi, by
the
the way.
lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendi Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph, that he knew she had these accounts because he managed one of them. And he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendi filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come
Then-
back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied. Did my client in the emails you review appear to push back on Wendi and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Is it possible to undo this? And then Wendi responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to tell me. You know, sometimes I say, you know, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position and maybe theirs will change.
Now, you were provided with a number of emails that Wendi was sent by her mother. Did you see evidence that Wendi shared those with Kristen Adelson?
I saw no evidence that Wendi shared them.
And did you speak with Ms. Adelson about that?
Yes.
Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adelson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendi Adelson get the parenting plan that she was requesting?
Now, arguably, that's new information that she got here at the trial. Don't know for sure, but that was a question she was specifically asked and responded to. They talked for a full hour before they got to the court, so it's possible she already knew that as well.
In her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days, with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, you know, the division of childcare, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
It's based on a number of factors: income, childcare, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that by agreement.
And you mentioned keeping the boys kosher. Was Wendi Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No,
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
no. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No,
Was Wendi Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
no,
Was Mr. Markel granted every Jewish holiday?
no. I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendi Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say, you need to go to your therapist and follow their advice.
Was Wendi Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements because kids don't want to see the parents fight every birthday.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendi a lump sum and Kristen Adelson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendi Adelson and $10,000 towards attorney's fees to Kristen Adelson.
So I'll pop in here just to wake us all up a little bit because it is kind of dragging a little bit. So essentially what they're talking about is the details of the agreement between Wendi and Dan. And they're suggesting that, frankly, they had it pretty worked out. Donna may have been involved in the background. That wasn't impacting what was going on at all. Wendi wasn't even passing that along to her attorney. And in fact, there wasn't a ton of that anyway. There was this brief period right after the relocation was denied when Donna seemed to be under the impression this might change. And once she realized, no, this is it, and Wendi wrote her an email saying, look, I'm at peace with this, then Donna let it go as well. And that the division of care for the children was really very fair to Dan Markel, that it was 45-55 while the kids were younger. When they both got into school, it would be 50-50. And that Dan Markel was pushing for some unreasonable things, such as sole decision-making, which was never going to happen. They seem to be placing a lot of stock in the idea that Dan seemed to be writing these documents himself. I don't know why that really matters so much, other than maybe he was overly invested. Maybe that's what they're trying to argue. But basically, they're just trying to paint a picture of this not being the big motive that Donna supposedly had for killing Dan Markel. This wasn't the kind of thing that would result in a murder. That's where the defense is headed.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendi's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendi Adelson?
Yeah. Yes.
Now, later,
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those and they got a very typical marital settlement.
So from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markel were due within 60 days. So that would have had them due at the end of September. And so, taking Kristen Adelson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did. And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendi to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendi was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendi waived her right to appeal that by agreeing that the relocation would be dismissed. So
Now, prior to final judgment being entered, would Wendi have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
she could have.
Would there be anything improper with Wendi or her family through Wendi offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation. So that's routine.
Nothing unusual about that.
Routine.
So once again, suggesting that the state suggestion that this $1 million bribe, which is what the state calls it, to Dan Markel, there's nothing unusual about that. What you're trying to do is figure out, is there a way we could all agree to something different? If the issue is money and flying back and forth to Tallahassee where you teach, then that would be something that we could pay for. So that's the defense position.
Now, you testified earlier that you were provided text messages between Wendi Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it's a few month period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
You mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness? Approach with courts. One states demonstrative A, specifically page 338.
I assume he's only giving her this because it was the opposite of what she was thinking.
Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause. And under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendi is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here. She's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid.
So essentially what both of these witnesses have done is tried to say everything Wendi was doing was fairly normal and straightforward. She wasn't being vindictive. She wasn't demanding contempt. All she wanted was her money that he promised to pay. And she was basically behaving. During the divorce, it was Dan Markel who was not.
So that's his full exposure.
And let me add to that he had been right up until the very end. And then he seemed to change in the way he was handling things.
In the scheme of this dissolution and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markel?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markel emailed the parenting coordinator and Wendi Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendi in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendi to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kid said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markel?
I'm sorry, Mr. Markel's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendi had these other financial violations. And then she referred to the Schwab account that you've heard about, a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendi. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendi Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that. And it wasn't legally supportable. in my
That's not a
opinion.
valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement, is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in a financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540. And that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
I just don't know if this is reaching the jury. It's just so slow. It's so ponderous. I don't really know if the jury is going to be kind of following along. It is really slow. It's dense, detailed legal stuff. I don't know. It's pretty easy what they're trying to say. They're just saying Wendi was reasonable, Dan Markel was not. Dan Markel should have paid up. He didn't pay up. Wendi was very reasonable in her response. He, however, went off the deep end and started filing other stuff because he was just all upset. He was irrational. That's basically what they're saying. And it's dressed up and talk about responses and violations and motions for contempt and the exact code section that's being cited. But basically, that's the point that's being made. I hope for the jury's sake that at the end he'll pull that all together with a few specific questions so that can be explained to the jury. But I don't know. Give me your thoughts in the chat. Is this something, are you following it or what? Like, does it seem just too dull to really follow? I'm really curious what y'all are thinking. We'll do a poll on that.
It's a high hurdle.
Sure, and it had to have impacted you. In this instance, it was clear from Mr. Markel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendi on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go to dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them. And they were little babies. And he didn't like that because he wanted to be able to go to the childcare during her parenting time so he could see them every day. And I think the childcare person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before my recollection was correct. She filed a motion to dismiss on March 10th. To dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show material and substantial change in circumstances and that it was in the best interest. And there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in his motion, he says, I don't know if this is true or not. I don't know if Wendi was present or not, but I would like Wendi to make it stop if it's true.
Did this motion, the March 26, 2014 motion that the state is called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe 0.4 or 5, and then he kind of tied in this grandparent thing on 0.8. But what he was appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school. So he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendi to have to call him so he could watch the kids, even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if my rule, or what I tell my clients is, if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or, you know, anything like that. That's a normal part of a kid's upbringing. And so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Now, have you?
I do want to throw in one thing too. The state, for the two trials that I've covered, Charlie's and this, has very much characterized this as, they've talked about the grandma motion. They've talked about this refusal to let Donna have unsupervised visitation. So it is critically important that the defense set straight what the exact story is. Does it mean that Donna didn't have hatred in her heart for Dan Markel? No. Does it mean that Donna was completely uninvolved in the murder of him? No. But if it is inaccurate to say that Dan Markel wanted to prevent Donna from seeing the kids unless she had supervision around her, and if that's not true, then it's important that the jury know that. So that's what these two witnesses are doing, is setting the record straight for purposes of making sure the jury understands what actually happened.
Ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar to what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all, because it was a complete waste of everyone's time and money and emotion, because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his filings?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert by role here. You know, it was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendi Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have. And that's one of the reasons I wanted to call Kristen, because again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense. And I wanted to get Kristen's take on that and see if she agreed. And she did. And she said that she had advised Wendi of that. And that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendi had sent her mom a couple of documents. I know the petition for relocation that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions. Because like Ms. Adelson said, relocation is extremely difficult and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing communicate, either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markel been able to sustain his burden of proof for that motion?
I'm sorry, say that again.
Would Mr. Markel have been able to sustain his burden of proof for that motion?
No, I don't think so at all. If you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay. And I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case or a high conflict case. How many pages are in the court file?
There's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Do you know how much in attorney's fees Wendi Adelson incurred, attorney's fees and costs for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adelson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
May I show the witness to the demonstrative?
You may.
This is my cousin Vinny right here, some courtroom theater. And what this is payback for Georgia Kappelman dumping that heavy notebook on the table in front of Wendi and going, "Is this your divorce file?" And I will say, when I saw that, I thought, that is not a file. That is not a significant file. I know I have had cases where the file would take up the entire length of a room, multiple rows of it. I thought, that is not impressively large. I'm just not seeing it. So what we have here is lawyer comedic payback. They are paying Georgia Kappelman back for that. He's going to outdo that. Let's see.
Volume 1. Volume 2. Volume 3. you recognize this file?
Yes, I think I forwarded this to you.
This are these 10 volumes, a example of a hotly contested relocation case.
Well, and I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were two.
In my
volumes.
case, we would get 100 boxes from the other side. This is not impressive to me personally, but different types of law have very different sizes of files. It really depends on the kind of law you're doing at the
On the
time.
record on appeal, so perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
So Wendy's, here's what she's saying. Wendy's would have been one notebook. A really contentious divorce would be 10, and a or custody, really contentious would be 20 volumes. So Wendy's was small peanuts. It wasn't any big deal, wasn't all that contentious. And what does this all go back to? The question of whether Donna Adelson had a motive to kill Dan Markel. I did see a pretty good comment from Camilla in here saying, well, the question is really not whether this was the most contentious divorce, but whether Donna believed it was the most contentious divorce or too contentious, whether Donna was upset about it. So I thought that was a good comment. Thank you, Camilla. But that was some great My Cousin Vinny moments in court.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
So stay.
Judge, may we approach?
Yeah.
Judge, we're entitled to make a record. I believe I have the.
Members of the jury, the bailiff will take you into the jury room.
So he wanted to approach to say why he wanted to get this testimony, and the judge said no, which is the first time I remember him saying that. So now he's taking the jury out, and I'm not sure if we're doing a lunch or if this is just a break while he hears what the argument is. The defense lawyer said, I do need to make a record, Judge.
You may be seated. The relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendi Adelson and Mr. Dan Markel.
Kappelman, any other argument on this issue?
He plans to rule against him.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce file certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
So I think if he had asked it a little bit differently, if maybe what he had said was, give me some types of issues that would be in a truly contentious and tell me if they're in the case that Wendi Adelson and Dan Markel had, then he might have gotten away with it. But he was asking about another trial that's not related to this one or another case, and that was awfully specific. So the judge is shooting that down.
Ms. Bailey, please step out of the court or the courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room, please approach.
Oh, interesting. So he's having Bailey step out in the lawyer's approach. He's mad. He's still mad from the sequestration issue. He's still upset about that. That's what I say. That is my opinion. So the lawyer said, well, it wasn't my intention to do that, Judge, and which normally wouldn't really be all that hot button an issue for the court. But I think he's upset. I think he's still upset from before. So it's been kind of slow. I think they asked her to step out. I think she should step out, like out, to not stay in there. He's asking, like, is she supposed to be out? Yeah, we don't need to be staying in the room anymore. We've been through that. Get out of the room, definitely. So now she is. That's no longer going to be an issue. I think that they have a point that she could explain what hotly contested would mean.
Do
What
not
it,
make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. Jurors using the restroom. Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
okay. Okay, well, we're going to take a little break then. All right. Well, that got a little spicy there at the end. I'm not sure who had some motions or expressions that might have influenced the jury. Can we go back and see if the courtroom, let's do that. We'll just pop back over there and see if any of that.
Mr. Dan Markel.
Kappelman, any other argument on this issue?
So we had that. I want to see if there was some motion. Okay. We came up there. The judge ruled. Oh, no, it was before that. Before right here.
Court,
Entire.
And they said,
please bring back your case as it relates to divorce. This witness may testify concerning. her
okay, so the
experience.
judge rules.
I'm not going to go through
I want to see the facial expression that he was, it must have been that he was upset
Your
about.
Honor, that was not my intent to go through the case
Right
file in
there.
its entirety.
Okay.
Ms. Bailey, please step down, step out of the.
All right. So what I heard that time was Jackie Fulford said, can we please approach? And so that was what happened. And now we're going to be back in. So I'll go ahead and flip forward. We were just a minute or two behind. So we'll go ahead and flip forward to that. Well, we've had a lot of weird stuff happen today. This has not been your typical court day. Let's go ahead and tab forward. There we go. So they're putting Bailey back on the stand. I've forgotten her first name. Bailey was her last name. She's the expert attorney who is testifying, Linda Bailey. I'll tab us forward.
Continue with your examination.
Okay, there we go.
Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language. But when you really looked closely at his requests of the court, there was no there was no foundation for his asks.
Nothing further, Your Honor.
Cross-examine.
Whoa, he is not breaking for lunch. We are cruising through.
What is it you were asked to do in this case?
Let me clarify. He is going to break for lunch because he said he was going to actually do a long lunch to give everybody time to discuss the issue of whether or not Donna Adelson was going to testify. More specifically, the defense, the time. And then they would talk to her. If she's going to not testify, of course, they'll have to run through the questions that you say to the juror. And if she decides to testify, he'll have to run through the warnings and the instructions that she doesn't have to do that. And this is her choice. So they're adding a little time in there because the defense is still making the decision about what they're going to do.
Asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that?
That-
Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case as a lawyer might be routine, whereas to the parties it's the most important thing in the world?
To some degree, that's one reason I called Kristen, is Ms. Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, it's going to seem messy, but there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendi.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers.
People's lives change after divorce, certainly.
So like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. You get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I
litigation?
just want to say something. Did you see the way Georgia Kappelman did that right there? She said, "You can't agree with that," and she threw it. You can't agree with that, and she stated, "I'll withdraw that." That's very much testifying about her opinion about what the witness said. So some judges would get upset about that. Some judges would not like that. But the defense isn't objecting to that. There was no objection, that was she's not asking a question. Nothing was said. And therefore, I don't think it's a ground for appeal. If they don't object, it will keep coming in.
Never had anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
Derived.
that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't.
Exactly.
It shouldn't have been. There was no proof,
It shouldn't have been, in your opinion.
in my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
We're kind of using her expertise against her.
Mr. Markel wasn't paying by the deadline. Isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Ms. Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think on,
Even the word exactly saying is communication about the point. Saying that was exactly my point rather than rephrasing for another question.
that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously.
But that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
Yeah.
Adamson was incorrect on that point, I guess.
Your Honor, that's a question I need to strike.
Okay, there you go. Finally, an objection on that. Because that was Georgia Kappelman testifying about what Ms. Adamson said. So now he's objected on that one.
I'll
Was
rephrase
the-
it.
Was the objection again?
It's an improper comment on the witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendi. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever. And then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 due Wendi. It was only the $10,000 due Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendi taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendi then forwarding those answers to her mother?
I don't recall that. I don't recall saying that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post denial, post stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud. And it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
I think to some extent, the prosecution here is falling into a hole they don't have to fall into. It doesn't really matter if Dan Markel was being difficult about this. It doesn't matter. The only question, which is what she started with and was the most important point, was Donna Adelson upset about what was getting filed? That is ultimately true. Her point about this attorney is not the person we are looking at to see if she was shocked, offended by the pleadings. Instead, we're looking at whether Donna Adelson was, and was she enough that it became a motive for her to be involved in the murder of Dan Markel?
So they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in the public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay. So if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well-
would have been shorter if somebody gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended. If that's
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
no, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled, the witness has provided an opinion, state
Well-
or cross-examine.
Reams of paper is entirely
I guess
fair.
my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendi have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off. So
But that hadn't happened yet.
it had not happened yet.
And we'll never know when that was going to happen because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Yep.
Okay, well, it's been pretty fast paced compared to the original questioning. I think the judge wants to get this witness on the stand and off the stand and then clear the way so that the remaining witness is Donna Adelson or not. It's possible that there are more defense witnesses, but the fact that they're so determined that over lunch is when they're going to make that decision about Donna Adelson suggests to me maybe this is the final potential witness for the defense. We will see what they decide. They're being given a long lunch, although when that will occur, I don't know. We haven't had one yet. So I saw somebody complaining about Nightbot is giving out timeouts for saying that you think the witness is lying or to use the word lie. We have gone to battle with them over that. Nightbot, we cannot get it to stop giving timeouts for that. I guess that's like a trigger word on many channels. But anyway, I'm sorry. I realize you may be expressing an opinion about the case, and I wish I could make that go away, but we haven't been able to figure out how to convince Nightbot not to give timeouts for that. They're just 5 seconds, so that's good. Wait, we cut it down to very low.
Ms. Biggs,
Let me make sure. I saw there were some words in there. Nightbot, it's a
Bailey,
YouTube thing.
You sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
That was
This
important.
witness be recalled at any point.
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
2:15, so an hour and 15. That's what he's giving them. All right, we'll fast forward.
Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioned the gallery again. I don't know what steps the court needs to take in order for that to stop, but the fact remains that they're doing this in front of the jury, could have an impact on the jury, and it could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is this coming over my right shoulder.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Desclazo, I believe, is still to be called by the defense.
Yes, Your Honor, Mr. Scalzo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please scan the courtroom to make sure none of the witnesses are present, so we do not have any continuing violations of the rule of sequestration.
They do deserve
I
that.
don't see any witnesses in the courtroom, Your Honor.
Please return at 2:15.
Okay. So here we go. So it sounds like they're mentioning 2 more witnesses for today, and frankly, it sounds like that's all there is. Remove that and stop it and go full screen. Okay. So it sounds like they have 2 more witnesses, and then there's the big question. Will Donna Adelson testify? And the judges told him this has to be resolved over lunch. Don't be holding out on me. We need to figure it out, and we need to give her the instructions that you give either direction, whether she decides to take the stand, and it has to be told she doesn't have to, or decides not to. Either way, the judge needs to make sure that she's doing this with understanding of the consequences and that of what her rights are, and that, so they'll read through all that with her, and that has to be done over lunch. So that has to be done during this period. So we're only going to take a brief break, so we'll be back in plenty of time for that, at least I think, assuming they do it toward the end. In fact, I'm not going to keep that running because they play noise sometimes. But okay. What a weird morning. Am I right? It was bizarre. It was just by far the most bizarre day of trial. We had so many non-case related things that happened. I mean, they were case related, but not directly related to the case. It was just a very, very strange day. So we had some testimony that I think was not all that exciting, but the point of it was to cast some doubt on what the state has claimed. The state has painted a picture around the divorce between Wendi and Dan. Very bitter, hard fought, would have hurt feelings. Dan wanted to keep Donna from being able to have unsupervised visitation with her grandkids. That would upset anybody. So these 2 witnesses were here to say it wasn't really that bad. It was all divorces, painful, difficult decisions, but compared to others, they were really kind of getting along. The cross-examination of the second witness kind of undid a lot of that with a single point, that what might seem small and not all that important to the people who are the professionals, to the attorneys, might seem like a really huge deal to a grandmother who wants to spend time with her grandkids. And so there's a difference in perspective that has to be taken into account. The fact that the attorney wouldn't see it as that big a deal might not mean that Donna Adelson wouldn't. All of this is aimed directly at the question of, does Donna Adelson have a motive? Does she have a motive to kill Dan Markel? Because this is what the state says the motive is the ability to get those kids down to South Florida. So they've asked all the questions around that. Here's what I think we ought to do. I want to do at least, I'll leave, well, trying to decide how we should do this. I think we ought to do this. It's pretty late. Let's go ahead and take our 20 minutes right now. And I will be back at roughly 120. I'm not 101, so 121 to 125 range, somewhere in there. We'll be doing Q&A. We're going to be doing polls. We're going to be getting your ideas. This will give me a little time too to go through my notes from this morning. So, all right. Well, I cannot wait to talk over this morning with you. I also have some people. Let me go ahead and do this part. So we have some, are there any people in here? I think I said thank you to Donna, much appreciated. And I am not sure if I welcomed Allison as a new member, but welcome. Mindy has been a member for 16 months. That's awesome, Mindy, thank you. And she making trial watching easier. Well, I'm glad for that. Breezy Coyote is thinking that the professor lifestyle sounds really pretty fun. 2 days a week. Maybe the $1 million from the Adelsons really can make that easier. Who knows? So Camilla, we pointed out her comment earlier and talked a little bit about the point she was making, which was exactly the point that the prosecutor, Georgia Kappelman, made when she first got up. Sycamore Sally has been a member for 17 months. Thank you, Sycamore Sally, and talked about how she felt about the way the expert was testifying, that it was blaming Dan Markel as opposed to talking about the issues of whether or not Donna Adelson herself had a motive. Nina is asking me an interesting question. Do I like the live streaming or prefer the recaps? Well, honestly, I can't do the recaps without watching the entire thing. I know there are lawyers who can do that. They can just talk about it. I have to have all my information, I feel like. Otherwise, I don't know what to say. What would my comment be? So I've enjoyed both. I've really enjoyed your comments and your reflections on what you're thinking. It's so fascinating to watch your comments kind of in real time and then talk about it, and your questions. I've really enjoyed that. So what I will do in the future, I don't know. Your input is obviously greatly appreciated. And Estella thinks this is all very intense. It is really intense, especially during the period of time we hit toward the end there, where Georgia Kappelman was cross-examining all the drama around the witnesses and whether they'd be able to testify and whether they were breaking the rule that they were supposed to be outside the courtroom. We've had a lot of drama today. We've had a great deal. So, all right, what I'm going to do is I've got to stop that screen share a different screen with you. And this is the one I'm going to put up, and to tell you that I will be back shortly. We're going to take about 20 minutes. So basically 1:25, and I will be back as soon as I can. Hi, everybody. Welcome back. I hope everybody had a great lunch and enjoyed it. We are back. By the way, if you're live, if you're with us, if you would hit the like button, let YouTube know, yep, we're back. We're here. If you haven't hit that yet. What a morning. And it was strange. It was just really bizarre. We had all these outside issues that popped up. There was the judge instructing the entire gallery very sternly that if there are any outbursts that might attempt to influence the jury, even facial expressions or anything like that, then he is going to first have them removed, and secondly, they'll be subject to contempt. So he was wasting no words on that, mincing no words on that. He also said there was a discussion about whether or not there was an interference with a potential witness for the defense. Was the sheriff's office trying to prevent one particular witness from testifying on behalf of the defense? And it ended up kind of being a nothing because the defense withdrew it, but they had wanted to talk to this person and they said the sheriff's office was preventing it. It apparently is someone who works for the sheriff's office, an officer, I'm guessing a correctional officer who works within the jail system and had something to do with the prisoners who have testified against Donna Adelson. But we got no more than that. We only got that cryptic discussion in the background. And then there was the witness who sat through testimony, the lawyer who sat through testimony, despite the sequestration rule, where the judge has said, you can't sit in here if the testimony is going on, if you're going to be a witness. You've got to be outside the courtroom. And that sequestration was invoked for all witnesses. There was an exception that was made. And the experts for each side could listen to the expert testimony for similar experts on the other side. There's a pretty good and obvious reason for that, which is if you are hearing that testimony, that will enable you to respond to it, right? It shortcuts it instead of having to hear it from the attorney representing the party you're working for. Like, here's how it would work if that didn't happen. The person would have to say, let's assume, please, if you would presume with me that the other side said blah and blah and blah and blah, what do you think? That would just take a lot of time. So what they do is experts typically do listen to each other's testimony, read reports, so they can respond directly and say, well, I disagreed with this point and that point. I agreed with this point and that point. So that they can kind of shortcut things. That's typical. And the two sides had agreed to that. But the witness who was testifying was an attorney, but not an expert. And additionally, she was an attorney also working on the side or be testifying on behalf of the defense. So there was just no justification for it. So the court found there was a violation but said the question was whether or not it substantially influenced the testimony. And since the witness said it did not, he said the witness can testify, but it was up in the air for a little bit there. So we've heard from two attorneys this morning, one who represented Wendi Adelson in the divorce and the other who talked more generally about the issues around the divorce between Wendi and Dan Markel. So that is how we have spent the morning. In the afternoon, we have two witnesses, at least one of whom is an attorney, Marisol Descalvo, who was the attorney for Donna when she was first arrested. At some point after that, Daniel Rashbaum became Donna's attorney. There's also up in the air the gigantic question, will Donna Adelson testify? Everybody wants to know the answer to that, and we don't yet. But today's the day we find out. The judge has given them a deadline of during this lunch period. So at some point, if they have to come back for talking to the judge about this, which they will, they're going to break in, we'll go live, and we'll talk some more about what exactly what is happening. But the judge has said, you've got to tell me over this lunch period, because I need to know whether to give your client the instruction that, you may testify, but you don't have to. And I need to know exactly what to tell her based on what her decision is. Is she going to testify or is she not going to testify? So it's coming down to the absolute wire. Well, all right, let's here's what I want to do. I want to get your thoughts on what happened this morning. We had testimony from 2 attorneys. If I were to summarize, I would say their testimony overall was that the divorce between Dan and Wendi wasn't really all that contentious. It was kind of typical garden variety contentious, like people don't get along during a divorce. That's the way it is. Custody is a little tough. But that toward the end, particularly, Dan Markel was making it a lot more difficult than it needed to be. But even so, it wasn't that big a deal. He was filing garbage motions that no court would ever grant. And so there was no reason for the Adelsons to be worried about this. And therefore, Donna Adelson did not have a motive to kill Dan Markel. This idea that the divorce proceedings were so bad and she was so worried she would never be able to see her grandkids that she would go all the way to the lengths of resorting to killing Dan Markel, that just doesn't make sense. It wasn't that big a deal. So here's what I'm going to do. I'm going to head over here and I'm going to ask you your opinion about this. Okay. So attorneys said the divorce was not that bitter. And I'm going to change that to the divorce and custody battles were not that bitter. And I'm going to ask you your opinion first, just on that surface level question. We'll do several after that, assuming the court doesn't break in. And I'm going to ask you, I guess the question is going to be, do you agree? And your answer is going to be yes, somewhat. I'm going to say not really, I guess, like maybe a little. Not really. Well, I guess I'll just say not really. Oh, and then the last option I'll give you is absolutely not. Okay. Yes, somewhat, not really, and absolutely not. Okay, go. Tell me what you think about that. Meanwhile, let's talk a little bit about that. So the threshold question is, were they even right that it wasn't all that bitter? And now our second question is going to be, does that mean that it doesn't affect the motive of Donna Adelson? So our next question, I can't start it until we kind of finish this one, but I want to take it a step at a time. But the next thing I'm going to ask you about is whether you agree that it does or doesn't have a big impact on Donna Adelson and her opinion. So in other words, kind of what we're doing is assessing how significant you thought the testimony was this morning. So let me write this down, because when I do my recap at the end of the day, which gets posted separately, so you can always have a short version of today to watch. But I'm going to write this down. Okay. So attorneys said the divorce and custody battles were not that bitter. Do you agree? And we'll let it go up a little bit till enough people have voted. I'm not writing correctly. We're not that bitter. Do you agree? And our options are absolutely not is at the bottom. I'll say them in opposite order this time. Not really. Yes, somewhat. And yes. Okay, and we will see what you vote. So far, I'll give you a hint. I'm not going to tell you what it is, but one particular answer is pulling ahead of the others. I will say that. Oh, wow. The voting is quick. Y'all are in on this. You're ready to vote. You have opinions. I love that. All right. So I'm going to stop it when it stops going up so fast. And I figure most people are kind of voted. I'm going to stop it and we're going to go to our next poll. So the next poll question, and I don't, is going to be, if attorneys think the battle was not that bitter, how do I phrase this? Because it has to be really short. They only give me a few things, but basically what I'm going to be asking you is, we've heard from two attorneys. Georgia Kappelman's argument is, who cares what attorneys think? Does Donna Adelson think that it's really bad? Because this is maybe her one and only divorce case she's ever been involved in. So I'm going to ask you about that, kind of which way you fall on that. But I want to phrase it like, I want you to be thinking about, do you think that the mindset of the attorneys involved will impact the way that the litigants think, is basically what I'm going to ask you. So I have to think of a short way to put that, because that would be way too long. All right. All right. Okay, let's do it this way. If the battle was not that bitter, does Donna have less motive? How about that? I think that's what I'm getting to. And it's shorthand for what I want to know. All right, boy, y'all are voting. All right, I'm about to I'm about to call that one so we can get on to our next one. All right, so vote quick, but y'all are voting quick. Y'all are voting very quickly. All right, I am about to call it end of the, dang, I hate to do it when y'all are voting so fast like that. All right, I'm going to call it. It's gone. All right, so it is okay, absolutely not is 56%, much lower than it was at first. Not really is 25%. Yes, somewhat is 12%. And yes is 5%. So the exact opposite of the way they were in the poll. Very interesting. Most of you think that they were bitter, at least somewhat. The vast majority of you would be on that side. So let's go to the next poll. And this time I'm going to ask you, if the battle was not that bitter, and I'm going to put in attorney perspective, okay? Does Donna have less motive? So, and I'm just going to give you, no, I'll give you options again. We'll do definitely, somewhat, oops, not really, and not at all. Wait, have less motive. Okay, that's doing some double negatives. That'll throw me off, if not you. Maybe if the battle was not that bitter. Okay, I'll do this, but if y'all are thrown off by double negatives as much as I am, this may be hard. All right, how could I phrase that? Okay, let's phrase it. Does Donna have motive? Darn it, have motive if the divorce is not that bitter? In other words, does the divorce have to be bitter for Donna to have motive? Okay. And so I'm going to get y'all to say either definitely she has motive, even if the divorce isn't bitter. It doesn't matter. Somewhat, not really, and not at all. So in other words, if the divorce isn't that bitter, maybe Donna doesn't have any motive for murder. And this is probably too many negatives, but I will try really hard. Hopefully y'all can follow that one. I'm not sure how to rephrase it any better than that. So, all right. So as rephrased, the question is, does Donna have motive if the divorce is not that bitter? And you can see where I left it kind of intentionally open-ended, like not that bitter from whose perspective? Is it from the attorneys who testified? And as Georgia Kappelman pointed out, they're professionals. They deal with this all the time. What they see as bitter might not be what Donna Adelson sees as bitter. So I'm leaving it open for you to answer. It's a huge contention in the state's case. It's massive. So it's very important that they win this point. It's not the end all, but it's really important. Okay, so we got definitely, somewhat, not really, and not at all. So the question ranges from Yeah, I don't think the divorce has to be bitter for Donna to have motive to, if it's not bitter, she's got no motive. State is not proving motive. Remember, they don't have to, but it is awfully important. People really do care about that. So I'm trying to get your opinion basically about these witnesses and how important they were. And in fact, I'll ask it that way on the next poll as soon as we finish this one. So I'll let a few more people vote. And then we will call it. And because I think another way to put that would be, I'm going to ask you, were the attorney witnesses who said divorce was not bitter effective? Or maybe I'll say, were the attorney witnesses effective? And then I'll put in parentheses for shortness. Said divorce not bitter. Okay, and then y'all can tell me that way. Might be a little bit better way to ask it, actually. But I'll let everybody finish voting on this one, and then we'll go to our next one. Okay. All right, I'm going to close it out just a little bit. So go ahead and get those last votes in. Okay, I'm going to close it right there. All right, and I'm waiting for the results to pop up for me. It takes just a second. Taking really a second. Oh, there we go. Okay, so you think plenty of motive, even if the divorce is not that bitter. 20% of you think somewhat. 15% of you think not really, and 6% think not at all. So now we're going to ask a question that might be a little better focused to the case that I think maybe will help us kind of figure out what you thought about the testimony. Does Donna have, oh, that's the one we just did. Okay, never mind. Were the attorney witnesses, I have an abbreviation for attorney, effective? And I'm going to put in parentheses what they said, which was said divorce not that bitter. Okay, and we're going to do with the very much, very effective, down to somewhat effective, to, I guess we'll do not really as our next one, and then not at all. And not at all. Okay. Oops. All right, let's see your opinion. I think that might be a little bit clearer way to kind of assess what you saw about these. So it's so funny when the first answer comes in, it goes 100% to one answer. You think, wow, that is really an overwhelming answer there. So I'm watching your answers come in over here as you vote. Y'all are getting good at this voting. Y'all are voting very quickly. Everybody's poised over the keyboard to lock in their opinion on this. All right, I'm looking. It's, you know, one thing intriguing to me is this is not as divided as some of the others. I kind of appreciate that. It shows that there's a little more nuance to it, and probably shows that it's a little bit better of a question too that I asked. So what a strange morning, huh? I'm trying to decide how I can ask you about that. Oh, I know what we're going to do next. I need to do some questions too, but I do have another question for you. So how many do we have? Okay. Now I'm going to let some more people vote. Not everybody's voted yet. I know from the numbers we had in the last one that y'all are voting. I can see it going up. Okay. So we have two different attorneys we heard from today, both for the defense. We're about to hear from a third attorney. I think this third attorney is going to talk about reaching out to the Attorney General's office to find out if Donna could travel. To me, that's a really good point. I don't think it's fair to even hold it against her if she was told specifically by the Attorney General's office that it was okay to travel. To me, I would then completely dismiss that because they said it was okay. And she reached out. She even asked them then. So I'm curious what the testimony will be. Is it strong? Is it not strong? And besides, I could be wrong about what she's going to testify about. Okay, so I'm about to shut this one down. And okay, I'm going to end that poll and it'll pop up in just a minute. Okay, so not at all. Oh, wow, this was so close. Not at all and not really. So maybe a little bit. Both of those got 37%. They were essentially tied. Somewhat effective got 18%. And very effective got 6%. Okay, speaking just personally, I would put it in the somewhat effective. I did think it's important to know that this wasn't, the ultimate battle, that people from the outside, third parties would see it as not all that big a deal. But I do also agree with the prosecution that the ultimate question is whether or not Donna Adelson saw it as a big deal because it's her motive. So somebody could fly out the handle and act totally irrational about a very small thing. It doesn't have to truly be a big thing to inspire an out of proportion reaction. So my personal opinion. All right, now let's get into, remember, there are not one but two different witnesses who have violated the rule that they're supposed to be outside the courtroom when testimony is going on. These are both witnesses for the defense. The judge has said he's going to give an instruction to the jury about that. They haven't agreed on the wording yet. We don't know exactly what it'll sound like. But I want to know, let's say you were on the jury, okay? Would an instruction that someone sat in on testimony and should not have be important to you? Let's say you're a juror, okay? I misspelled testimony. I'm missing an E. Okay. So I don't have room for any more than that, but we're going to do that much, and we're going to do very much, and we're going to do, let's see, the next one will be somewhat. I don't normally do this because I want everybody to vote, but not sure. I'm going to throw that in there, and I'm going to throw that in there because maybe it would depend on what the witness had said, but not at all. Not much. I'll just put not much. How about that? Because I only get 4. Okay, so let's start the poll and see what you think about the judge, because the defense did pop right up and say, well, I don't know about this instruction, judge. And judge said, well, we'll work out the wording later. So they will argue more about it, maybe outside our presence, about exactly what the wording's going to be. It's not going to be known until probably for us until we hear him read it to the jury. So, okay, let's open up this. So that's how the judge is going to deal with it. Instead of excluding the testimony of the attorney, he's going to instruct the jury that 2 witnesses. Oh, goodness. I said somewhat. It should be someone. I'm sorry. That would be someone, not somewhat, sat in on testimony. Sat in on testimony and should not have be important to you. So sorry for that confusion. And okay, we got a winner. I'm going to go ahead and put them in order. That helps me when I do the recap. Okay, let's see how many votes we have. Okay, it's moving quickly. So we will let it go just a little bit longer. And that's the judge's remedy. Now, obviously, keeping the person out entirely would be a very severe remedy. And he looked at the case law, and so did the prosecution, clearly based on the one question they asked the witness in the proffer, which was, did this affect your testimony? And the witness said, no, it didn't affect the testimony. And that's what the standard is. So excluding the witness wouldn't have been appropriate under the case law. So the judge wanted a different remedy because he is clearly upset about that and still upset about that, it sounded like. So let's see where y'all are. Oh, okay, we're at something over 600 votes. So I'll give it another minute. So, and I see some of y'all are putting in some of the reasons you might think that. That's very interesting. Mitt Spunky, who has been a member for 11 months. We are glad to have you along, Mitt Spunky. He has been a very loyal member. Gave us a drive-by. Hey, he's driving. Do not text or put in any post while driving. Please, Mitt Spunky. We want you back as a member at 12 months. So we are counting on you being safe. Okay, so what an instruction that someone sat in on testimony and should not have be important to you. Okay, I'm about to stop it. All right, and your answer is, it will pop up in just a minute. Coming. Still not here. Still not here. Y'all must have really voted. They are still tabulating. Am I not at the bottom? There we go. Okay, very much influence you, 46%, somewhat 26%, 14%, and 12%. 14% were not sure, and 12% thought not much. Me personally, I think I would go with the not sure, which is why I gave you that option here. The reason is I probably don't care that they sat in on that testimony unless I think there's some underhanded reason, or unless I felt questions about their testimony anyway, and I wondered if they were shaping it around somebody. It would very much depend on the person, just for me personally, and what they had to say. So I would have trouble answering that question, which I asked you to answer, right? I had no problem asking you to answer that. I just couldn't answer it. All right, so Mitt Spunky, when you get where you are, let us know you made it, okay? That you did not continue to text. Don't text us now. Wait until later. We are glad to have you as a member. Oh, well, I think Jacob has a really good point. Here we got a comment from Jacob saying, if someone can't follow the court's rules, why should I trust them? And that, one of the things that about caused me to really come out of my chair was when the judge said, okay, to the attorney, who was already under fire for having been in the courtroom during someone else's testimony when she should not have been. He said, you step out and I will deal with this issue. So he told her to step out, and she went in just to the back of the courtroom and she didn't leave. And I said, leave, I'm telling you, leave the courtroom. He wants you out. And someone noticed, and the guard came over and got her out before anything happened. But I think there was some miscommunication, and she didn't know, I guess, that she was supposed to leave. But that of course, is going to be a problem for the defense. They are going to have to be super careful. They cannot have any more mistakes. Nothing at all can be another mistake. Okay, so let's do some questions too. So if you have some questions, if you could put question marks at the beginning of your question, that will help. And I want to be over here, make sure that I'm not missing anything at the court fee, because I would not be surprised if they break in a little early and start talking about whether Donna will testify, because he told them he wanted it during this lunch break. And there are only about 11 minutes left in the lunch break. So we are coming down to the wire. Will she testify? Okay, NK wanted to know, that this is a very good question, NK. Why did the second attorney feel it was so important to confer with and observe the first attorney? If the truth is the truth, right? That's a good point, NK. That's a really good question. I can't fully answer that as to what it was in her mind. I think this is true. I imagine she wanted to hear just exactly the way it came out. Her explanation was she wanted to make sure she had all her facts correct. But it turned out she did have all her facts. That's what she said. That was her explanation for it. So the thing about it is they had already met for an hour, she said. So they had talked personally in advance for an hour. So did it really help? Well, one thing it did was make sure they got their act together. In other words, one person doesn't testify one way and the other a different direction, so that they can be cross-examined, and there are problems around that. I think it surprised me. apparently they had asked specifically for her to be able to sit in on that exact testimony. And I think she just wanted to make sure there was nothing she said, oh, yes, this happened. And then as it turns out, that isn't what happened, because Wendi's attorney got on the stand and said something entirely different. So she wanted to make sure there was nothing she said that contradicted. But that's also in a lot of ways the reason why people aren't allowed to watch the testimony. So I think that's a really good question, not completely answerable, but a very interesting question. SOAR wanted to know about ethics violations. I am not aware of anything related to that in this particular case. I don't know, for one thing, the witness, the attorney, said that nothing about her testimony changed. And that was what the judge had read out as the standard. If nothing changed, then there's no problem with the person testifying. The point of it is to keep people from changing their testimony based on what they hear, or making up new testimony based on what they hear. Thank you, Dalen. Much appreciated. Donna will testify, says Meredith 2 cents. And you might be right. I am wondering how that's going to be something else. That is going to be honestly, that is going to be a sit back and dang, that's going to be crazy. That is going to be really something if she does. I want it. I really want her to testify. And I want Charlie to testify. And gosh, I'd like to have Harvey on the stand. Y'all earlier today voted that your most wanted witness was Donna, which of course makes sense. This is her trial. All right, so let's see. Another question. This is a question from Lisa, who was a paralegal for a divorce attorney. And one of their clients was unalived, she tells us, in front of their child, her child. Oh my gosh, and threatened the attorneys as well. That's totally terrifying, totally terrifying. And these attorneys and Lisa's attorneys might have said this was kind of a garden variety case, but clearly not from someone's perspective. I thought Georgia Kappelman's question about that was so good, because the witness had talked about she had once had a client, and the husband of her client unalived himself as sort of a response because he found it very shameful that he was going through a divorce, and in response did that. And Georgia Kappelman said, well, you don't think it's shameful? No, and you wouldn't do that. And yet this person did. So people have different perspectives over the same facts. Very true, very accurate. And I think Lisa has a really good point. Thank you for telling us your perspective and about what happened to you. Thank you. Miss Nell Scraps is gifted a Lawyerly membership. Thank you. If you are not a member, you can easily join by hitting the join button down by the name Lawyerly on the channel. If you're on your iPhone, you're going to need to go in through your browser instead of using the YouTube app. You also could go to your computer and do it. But other than that, you should be able to hit the join button. It's a way of financially supporting the work here on the channel. But there's a gift out there, and you can turn on your ability to receive the gift from Miss Nell Scraps, and she will, and YouTube randomly assigns that. So you might be the one. Our mods will tell you how. We are really grateful to our mods, Marlon and Mama Pinks, who stick with us faithfully and put messages like that in the chat for us. Mildred is very sad we won't be hearing from Chatterbox Charlie. That would be sad. That would be very, very sad. And I can only imagine the analogies we would hear. We have got to come up with a list of Charlie's analogies, because it is absolutely off the chain, the number of analogies he comes up with. Sometimes you think, how is it like that? I'm just not following. And in the same conversation, it will be 3 or 4 different things, from stirring up the bottom of the soup pot and things float up to who knows what. It's all kinds of crazy stuff. So yeah, Charlie is very, very entertaining. No question about that. So Christina is asking a very interesting question. What about what we heard today, does that reveal sort of a possible defense strategy for Wendi if she's charged and goes to trial? I'll tell you, one of the most interesting things to me is how different the approach today was from what we heard earlier in the trial, when Donna seemed to pretty much go after Wendi. That's not what we heard today. Today, it was pretty much setting Wendi out as really reasonable. Wendi acted reasonably and normally in terms of how she acted in the divorce. So pretty different. And I agree that it could, just as K8 McAwesome, I'm sorry, no, this is Christina, was saying, then yeah, I agree. It could be sort of setting out what Wendi would say. Wendi would be saying, I didn't think it was that big a deal. I'm an attorney. And I was being told by attorneys that it wasn't that big a deal. So I didn't really think it was. I fully believed my attorney's advice that Dan Markel was going to lose this. I wasn't worried. Donna Adelson, maybe she was. I wasn't. So I can definitely see Donna saying that. Thank you, Melody. Much appreciated. Glad to have you along. Melody is a longtime listener too. Very appreciated. And Ellie is a new member. Congratulations, and we are very glad to have you with us. Let me see, did I skip a question? Okay. So Blue Day wants to know, if Donna felt the divorce wasn't going the way she or Wendi wanted, couldn't that be enough to make her commit the murder or to have Dan murdered? And that is certainly the prosecution position. What the defense was trying to say today was, it was really over. Dan was filing a bunch of miscellaneous silly stuff. No one was paying any attention to it. The question was Donna paying attention to it, right? That's the prosecution's question. All right. Dave 007 asking if the defense divorce attorney testified like an expert. Yeah, I think so. I think for the most part, she talked about what the rules would be and what would happen. I felt like she did. That's pretty much all there is to it, really. Is, she was just telling what she would expect to happen and what she believed. Mary wants to know, is Charlie still available to testify? I don't know. I've not heard that they sent him back, but they may have. If I were the state, I would keep him around through at least rebuttal. And one of the reasons I would do that is I would want to make sure that I had the ability to respond to whatever Donna argued in her case. And until they know whether Donna's going to testify, until the last witness testifies, I would want Charlie there so I could call him if I needed to respond. That would be me. Pascaline, if I were Donna's counsel, what would I be saying to your client? Well, one thing that I thought was really unfair in Charlie's case was that apparently he was getting the word that, hey, this is going great. You're doing fabulous. Everyone loves you. And your attorney is great at closing argument. And you could tell from the conversations with his mother and their jail calls that he was stunned, absolutely stunned to lose. And he said that. I thought I was going home. He gave away all his food, all his canteen food that he had carefully hoarded over the months. He gave it all away. Like, oh, I won't be needing this. I'm headed home. And I feel like clients need a realistic view. If you look statistically, the chances that they're going home are very, very small. So I would say to my client, here are the statistics. I want you to understand them and to know about them. We're going to do everything in our power to keep that from happening. But I want you to have a realistic view of what's happening here, because that's how you will make your best decisions about things like, are you going to testify? So that would be my thought. And I would be disinclined to have her testify. I just don't see how she helps herself. I don't see it happening. Donna, could Donna's attorneys argue she's just a liar? Evidence on the phone calls when she didn't hang up the jail call. Well, they could. It could be a little controversial. I mean, I think they would need to run that by the client to make sure she was okay with that. But that would probably only work if she doesn't testify. If she does testify, that's really going to be a mess, huh? Lauren Crime. Did the two divorce attorneys help Donna's case in any way? So we took a poll on exactly that. And here is what the answer was. Not at all got 37%. Not really got 37%. Somewhat effective got 18%, and very effective got 6%. So that is your poll on that. I was in the somewhat effective category. I thought it hit at least that. I felt like the prosecution had a pretty good answer to some of that, which is the biggest question is Donna, not just what the attorney thought. All right. Mary has been a member for 2 days. That's awesome. We are glad to have you for both days. We are so glad, Mary. And she likes Charlie's percentages. So you like those. Okay. Well, we will, Charlie thought he was going home. I mean, he was all Mr. Optimism and seemed very surprised that he was not. He did seem to be pretty alert. There was one to what was going to happen after that. There was one question in there or one comment where he said Dan Roshbaum had stopped by to meet with him on his way out of town. And Charlie pretty much said, I get that, an appeal is a long shot. Appeal is not a very likely win for me. Absolutely true. Absolutely true. That's also a very long shot. Ironically, your chances at trial are even worse than your chances on appeal once you're convicted, but they're both terrible. Neither one is very likely at all. Okay. Oh, this is interesting. This is a good point. A very interesting point from Grazing Poro. In my opinion, as a political scientist in international law, Donna's case was made easier for the defense by not letting her get to Vietnam, because some of those agreements, treaties that we've talked about in extradition de facto would make her case much worse. So I can see that. It could be, well, isn't it true that you fought for, a year and a half to not be brought back, and they didn't have to do any of that. But it would be a lot of work and complicated, and people wouldn't necessarily know how to do it. So I imagine that was more the thinking. Would it even have been worth it to get her back? But in this case, they didn't have to. They got her at the airport. So thank you so much. I appreciate your comment. All right, going back over for some more questions to see what y'all are thinking. What are your thoughts? Janine G. That's a very interesting question. How do you think those people would feel if they knew their divorce files were brought into another court proceeding? By the way, I need to add in the My Cousin Vinny to my recap. There was a moment in the morning, for those of you who weren't here, when they brought in a bunch of big binders, a bunch of them, probably 3 boxes, 2 boxes of mini boxes anyway, of big binders. And these were just part of a file from another case that the attorney witness had. The point they wanted to make was that while Wendi's case did have a big binder, that's not a bitter case. A really bitter case has volumes and volumes and volumes of binders, and people have been fighting about it for a long time. So, but that is a good point. Those were from another case. I don't think that the names were visible and none of the personal or confidential information was visible, but I think that would be kind of weird. That would be a very strange thing. I think they might have a problem with that. I think you're onto something, Janine. That would be very uncomfortable. Do you think juries know the true meaning of reasonable doubt, or do you think people will find you guilty if they think you probably did it? So, interesting question. This comes from just A. And I think that the fact of the matter is jurors tend to find people guilty when I don't think they necessarily wait or understand reasonable doubt. Oh, the court's coming back. But that's one of the reasons that the court explains it so carefully in hopes that people will internalize that. Let me stop the screen and then share the screen. Oh, I got to turn on the. We'll back up.
The first concerning the waiver of attorney-client privilege as the testimony of Mr. Sclazo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further calls?
Yes, Your Honor, the waiver is specific as to the counsel that our client received from Ms. Descalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf.
So I think they're waiving it as to her trip to Vietnam and the just communications around that. I don't know you can put such a guard around it. We will see what the prosecution thinks about that.
Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do.
What is that scope?
The information that we discussed after my son's trial regarding my travel in the state of Florida.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Okay.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way? As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, will you be able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times.
Yes, Your Honor.
Yeah, if I may judge, the issue is that
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
the issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends.
Right. This is the issue in every single case. There's absolutely nothing unique about this. You, at the end of the prosecution's case, you have to determine, are you going to testify or not? There's that 100% of the time, that's what people have to decide. There's nothing unique about the choice that's set in front of Donna Adelson.
What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically the recessed court early for you to address any issues of witnesses or whether your client will testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed. So we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter.
5 minutes.
The defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that we will get started momentarily.
So it is down to the wire for Donna Adelson. She's got 5 minutes, and we are all on the edge of our seats wanting to know, is Donna Adelson going to testify? Is she going to refuse to testify? We don't know. Here's what the attorneys would love to do. They would love to go through everything that has been discussed and say, okay, what could Donna say in response to this? What should she say in response to this? Or is this a reason just to give it up? You can't really testify about this. That's the kind of thing they'd like to look at. I'm going to make sure we're all the way at the end. Okay. So they would love to have that ready to go, so she is fully prepared. But as far as getting this decision is just exactly what every defendant has to make. And there's never enough time to do that. No defendant has enough time to go through the entire prosecution case, prepare each and every response. Well, Charlie pretty close to did, but for the most part, that's just, you have to make that decision on the fly. There's new evidence and you have to be ready to take it into account. So for all the times that I've said, gosh, would I ever testify? Would I not? They're on the offense too. They apparently are really, really on the defense. They don't know what to do. They still haven't made that call. They still haven't decided. And they're trying to come up with a way to give her advice about what to do. But this is it. They've got 5 minutes and they are going to be called upon to give the final answer. So we will either, I think we hear from Donna Adelson today, or we never hear from Donna Adelson ever. So there you have it. This is going to be absolutely a wild afternoon. And if we don't hear from Donna Adelson, I mean, we could be zipping right into the state's case, the second half of it. Oh, we're already back.
Concerning things that are said by the defense. And although the proceedings are public, that has not stopped Peanut Gallery from their comments and laughter. We are respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
His approach, we're not going to do this for very long.
Okay, so one thing I can see her being really worried about is, how does she deal with the Charlie issue? How does she deal with the Wendi issue? Because those questions are going to come up and she is going to have to come up with her answer. So if she's going to if her lawyers want to, in closing argument, throw Charlie under the bus and Wendi under the bus, they're going to have to say things, and she's going to have to answer questions that fit with that when she's up there on the stand. I know she doesn't want to do that, although she came in pretty hard on Wendi at times during this trial. Not really Charlie. There was one point early on, remember, they mentioned the 4 people who were involved, and Charlie was one of the people mentioned. But for the most part, I think she has pulled back from that. I don't think there's been, certainly in recent days, much throwing Charlie or Wendi under the bus. She seems to, but now she's going to have to decide. Is she going to agree with Charlie's story about the extortion? She wrote people right afterwards saying that it was true. So probably she's locked into that. Absolutely fascinating. You can feel the tension in the courtroom because this is a critical decision that makes the trial go in two different directions. I think the bottom line is the cross-examination of Donna Adelson would be a disaster, absolute disaster. I don't think there's any coming back from it. So I think it's hard for her to win if she doesn't testify and impossible for her to win if she does testify. So it's difficult either way. Does she have some strange story we don't know about that could come out? Maybe. It would be absolutely fascinating to find out. Yep, there you go. Jacob, I think, has what I would say too. I want her to testify. Yes, indeed. I definitely want Donna Adelson to testify. But if I was representing Donna Adelson, I'm going to tell her not to testify. I'm going to tell her, yeah, that's way too risky. Are you kidding? I mean, Georgia Kappelman does a cross-examination that's very sarcastic, that's very hard hitting, and she doesn't miss anything. So it's going to be brutal. It's going to be really brutal. And so any kind of squirrely argument she wants to make, Charlie, I mean, she's not going to get away with anything. So it's going to be very, very hard. So I do agree with Jacob. That is just really crazy. All right. We're going to do another poll. What do you think? Should Donna testify? And we're just going to do yes or no so we can get it up as fast as possible, because if we don't hurry, you're going to already know the answer. So what are you thinking? Do you think she should testify? Oh, wow. That's pretty close so far. I think this might be the closest poll we've ever done. Usually they're one way in, a long way in one direction. Should Donna testify? Okay. And y'all are voting fast. You got to lock in your vote, because we'll have to end it when they come back, because then we'll know the answer. That's no fun. But the pressure, I mean, I think, to me, the worst thing would be, and I guess I shouldn't say this while y'all are still voting, but most of you have probably already voted. Many of you have voted. I think I could not stand to be in prison for the rest of my life telling myself I should have testified. I should have stood up and said something. I think that's the way I would ultimately decide it. Although I know that that is not the wisest advice. And if I were a lawyer representing Donna, I would be telling her probably, well, I'm saying too much. I'm going to let y'all vote. Going to let you vote. So the two, I see a question about the two attorneys conferring in advance about their testimony. They're allowed to do that. If they haven't testified yet, they're allowed to talk about, well, here were the facts. Here's what I'm thinking. There's nothing wrong with that. The rule only applies once the trial begins to people actually testifying in court. So this is really stressful. I don't know what's going to happen here. Allegation maybe. So grazing, I'm not sure how to pronounce that, but anyway, grazing, we're going to go with grazing. If the allegations are true, maybe Donna is narcissistic and will testify. That's sort of what I think grazing is suggesting. Maybe that's something that she won't be able to resist. So y'all are voting. Wow, we got a bunch of votes. Y'all are voting fast. I'm not gonna cut it off till we'll see when they yell break in the huddle. Okay, break, and come back and give us the answer. That's when we'll cut it off. So well, now I've got so many windows open. I want to make sure I keep one eye on the court so we don't miss anything on this. Kathy wants to know, can she still appeal if she testifies? Yes. She absolutely can still appeal. In fact, Charlie testified and he's appealing his case. You just can't appeal on the grounds that whatever you said in your testimony, you chose to waive your right not to incriminate yourself. So that's not a ground for your appeal, but there might be other grounds for your appeal. So it's still possible. All right. I said I would let it go, didn't I? So I'm gonna let it run. As we wait for the momentous decision about whether Donna Adelson will testify and about whether she will take the stand and tell us what happened in her own words and in her own way. We will see. We will see. So we can do some questions over here if y'all have some. Put the question marks at the beginning, and that'll be my clue as to the fact that you have a question. All right, I'm looking back. Oh, there's one from, that was the one I answered from Kathy about the can she still appeal? Oh, wait, there's one from Laura. Have you ever seen this kind of late debate as to whether a defendant should testify? I think this is true indecision here. They really don't know the answer. They have not decided between them yet. But this is huge. I mean, this is really big. We are on the cusp or not of the moment when Donna Adelson decides testify or not. That'd be a brutal decision. I do not envy anyone making that decision. That is really hard.
You can bring the jury.
Okay. What will the deal be? All right, I'm going to go ahead and call in the poll. Okay, I'm ending it. 55% of you are no, and 44%, so that means some percents or decimals, are yes. So most of you, no, Donna should not testify. Thank you, Miss Nels Krauts. That was very kind.
All right, we're entering the courtroom.
Well, they aren't telling us. Why are we not getting the word here?
Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for defense exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state? Defense 50 is admitted.
Thank you.
So what really should have happened, in case you're wondering,
Defense, we're calling Marisol Descalzo.
okay, they should have probably admitted that exhibit during Luis Rivera's testimony while he was still on the stand in case there were any additional questions, but the state is just saying no objection. They're going to get that in. And now this will be part of the testimony of the witness, I guess, for use in her testimony. I don't know how or why with Marisol. It says Donna's former attorney.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? You may be seated. You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
And what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Um, During that time period when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yeah. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Grashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
So when she's saying we decided to call Ethics Council and the Florida Bar, what she's saying is that as attorneys, we have certain responsibilities. Sometimes it's not really clear exactly how to handle those. Ethics Council would advise you as an attorney on how to navigate through that to make sure that you're acting ethically as an attorney. It would be someone who would advise you on that. And the same with calling the Florida Bar. They're trying to get advice on how they should handle this issue ethically, given the different constraints they have, the rules they're under in order to represent clients.
After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
And specifically, there were no warrants for her arrest.
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson. So I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
And on November 6th, her son was convicted.
A quick answer. The self-surrender would mean, and she said it wasn't guaranteed, but that would mean that Donna would be allowed to, they would notify the attorney, your client's about to be arrested, and an arrangement would be made. Okay, well, on Friday at 8 a.m., my client will report to, and arrangements would be made so that it would be planned, rather than having people come out and put the person in handcuffs and take them off to jail. So she's saying they didn't guarantee me that. She obviously thought that might happen since they knew that Donna was represented. That's what the self-surrender she's talking about
Did you
is.
speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making a serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
further, Your Honor?
No.
Cross-examination.
Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended. Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to. I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so. Yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago.
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict.
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't. No, I had an attorney-client privilege relationship with her, and I didn't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of,
Overall, witnesses opined on this matter.
On November 6th.
Okay, let's
her
back
son-
up a little.
During that time period when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Okay, we can go all the way to the end. It blinked and I wasn't
I
sure.
don't believe that was a telephone.
What she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and she told us that what she really wanted to do was she wanted, to
Get away. Okay, we heard that.
okay.
Sorry, it blinked. I didn't want to miss
Are
it.
you aware of a text message where she said that she
Okay.
was
I'm not. I'm sorry. Was that a text message? To
This
me?
was a good answer, by the way.
I
Was
don't
that to
believe
me?
so.
Yeah, I don't.
No, I don't
I
know.
don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband, as something that would help her with her mental state.
Okay. So that's something they suggested, but not you.
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going,
Okay.
and it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, call for speculation.
Overruled. The witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight,
As her attorney,
okay,
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second. Specifically though about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you.
Good
Other
answer.
than what I said before, that it would come up at a bond hearing.
Thank you.
I mean, obviously, it's.
Examination.
Thank you, Your Honor.
Prosecutor asked you,
Mr. Scalzo,
prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
no, Your Honor, I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Well, Let's recall Sarah Newhouse.
Raise your right hand down. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Did you have occasion to get assigned to be the victim advocate for Wendi Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendi Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendi Adelson called her mother.
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay. And is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendi Adelson called her mother?
It is.
Okay. When Wendi Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
At this point in time, I move into evidence Defense 71.
Objection.
I haven't reviewed this exact item, but based on what the defense has represented on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that, objection.
A lot of qualifications.
Well, there's just,
Members of the jury, we're going to take a brief break. The bail will take it to jury.
So all this is, it's like really short. I mean, if you've watched or heard Wendy's interview, it's really big, very much a nothing. I'll make this a little bigger while we let them leave and take this break. But all it is a few seconds when Wendi calls her mother. She says, "Sit down, Mom. You know, Dan's been shot. He's not expected to make it." And you know, there's not much more discussion than that. It's just a brief conversation.
You can be seated.
So this witness is
Anyone need to
important.
Stretch their legs or use the restroom, please do it now.
This witness is important to the defense for more than one reason. Obviously, this particular reason, they want this witness to be able to testify just as she did, that Donna sounded shocked, that it appeared to be the first time she'd heard about it, that it wasn't, she didn't make any admissions like, "Oh yeah, I know he's dead. Well, it's finally got him." She didn't do anything like that. She appeared truly surprised. So that's one reason that this witness is important. But one of the arguments the defense has long made is that early on, nobody was thinking Wendi had anything to do with this because they gave her a victim advocate. They early on decided, oh, she could have, we pulled her in, but it looks more like she's a victim and we need to give her someone to support her through what she's going through. She's got 2 kids, everything's going to have to be dealt with. And so the very fact that this witness is involved in the case at all has been important to the defense. That's been one of the things that they've argued in the cases that have gone forward so far, at least Charlie's case. So we will see. All they want to do, I know that the prosecution is very unlikely to have an objection to this. It's just the sound of the call. There's video with it too. You can see Wendi sitting there, but it's not anything that's going to change the case one way or the other. So we remain. Let's make sure we are 100% all the way caught up. Oh, we were. Okay.
Wendi Adelson saying this is the worst day of my life before the call connects, and then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those 2 comments. I'm fine. I understand they don't tend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
Okay.
And as I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will be made. Bring back to the jurors.
Okay. So the defense had in there a little bit more than just a conversation, but they're not going to play it right now anyway. Maybe, I guess on their closing, or maybe if Donna testifies, maybe they would play it for that, and they're getting in a minute. Of course, Donna could have identified what she said, but I guess she couldn't have identified the actual recording. So maybe this means Donna's going to testify. We're all waiting for the big moment. Let me go ahead and pull this all the way up so we're all the way caught up.
And continue with your defense. 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
That's it.
Examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No,
Have you ever met her?
no,
So you don't know what her normal demeanor is like?
correct, I don't.
Okay. But Wendi Adelson, her daughter, presumably does know.
Correct.
Do you remember Wendi Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor, that's hearsay. That's exactly what was asked to be removed from the file.
Please sit down. That's the hearsay. Sustain.
No further questions.
Redirect.
Right, Your Honor, can you just strike the question from Ms. Kappelman?
Members of the jury, you are to disregard the last question of the prosecutor to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
That's two, your exhibit. Do you wish to publish or just leave evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that if we need two references, it could just take a few minutes.
Well, the jury will have a brief break. They will take you to the jury room once again.
Okay, so the poor jury, they're getting a lot of exercise this afternoon. In and out, in and out.
Everyone can be seated. Please make all necessary redactions and changes at this time.
Okay, so the defense had a couple of comments around that call. So the prosecution said strike that, and yet the defense's objection is then they asked for. There's no, the sound is on this, it's just not coming out. That's been turned off at the court. They seem to think this is outside the jury's presence. So wait, it's coming back.
If there are no other witnesses for the defense, it is time for the decision to be made.
Okay, this is it.
I can tell the court that co-counsel and my client are deep in conversation. I'm sorry,
I
that's
am capable of seeing that. No narration.
It's delaying. This is a delay tactic. Oh man, I cannot imagine having to make that decision. That would be so hard. No matter what you decide, you will kick yourself for the rest of your life.
Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
If not, if they rest without calling for the witnesses.
We could be it.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise.
Okay, and they're like,
Placed on
we're
oath
all
this
waiting.
afternoon. Mrs. Adelson, I will advise you concerning your rights. Do you understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case? Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I will.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss, or have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
She's
Mrs.
right. But,
Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify
All right.
or not.
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed, ma'am. What is your choice?
I mean, they really haven't decided. We're watching it.
As I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity.
We still don't know. We still do not know. They are killing us here. They are just dragging it out. So the one thing we know is that Donna also doesn't know. Donna has not really figured out what she's going to do here. And once again, the judge is giving them 5 more minutes, just 5 more minutes. Mildred thinks this is chronic Adelson arrogance that we are watching. She is pushing it hard. I mean, every defendant has to make this decision. It isn't like this is something unusual or something that's been thrown into the mix that only Donna Adelson had to deal with. I mean, every defendant has a case presented by the state, and then they have to make their decision about whether they're going to testify. It's exactly what everybody else does. But what you can see too is this is the last possible witness for the defense. If Donna does not testify, the case is over. The prosecution has said it's not even going to have a rebuttal case. Now, if she testifies, they may have a rebuttal case. We've already gotten that from them. So we are just sitting here. I am anyway. I'm on the edge of my seat wanting to know what Donna Adelson will decide. And it affects the entire rest of the day. As she points out, it affects the rest of her life. She is absolutely correct about that. But it's still a decision that has to be made. You know, Charlie was so readily decided about this. I mean, it didn't seem like there was any question at all. They knew from the beginning he was going to testify. Early on, there was every indication Donna Adelson was going to testify too. At a recent hearing, the defense lawyer twice talked about Donna testifying, said, well, one reason we can get such and such in is because Donna's going to testify. And that was pretty clear. They were headed in that direction. No one seemed to have any questions about that. But now it's definitely different. They are not decided. And it seems like her attorneys aren't sure either. I don't get the impression her attorneys are pushing her one way or the other and she's fighting with them. I get the decision that they're telling her it could be really bad. You might need to. We don't know. And she's saying the same thing. So I don't honestly, thinking through it, what's she going to say that's going to help her case? That's kind of what it boils down to. And I don't think there's anything she is going to say that can help. If there was some crazy theory that only she could put out there, and there was with Charlie, right? He had this theory, and unless he testified, nobody else knew about this theory. He was the only one, this secret extortion that went on when Katie extorted him on behalf of the hitmen. No one would know about that. But in this case, that's come in through another witness. Even without Charlie, it came in through one of the state witnesses. So they know what Charlie's theory was. The jury does. So now what's left is that Donna, what is she going to say? What is going to help her here? The only thing that I can see that she could say is, Charlie came to me with this extortion theory. I'm an over-involved mother, and I wanted to help him any way I could. Right? That's what I think she would say. But wow, is that going to open a can of worms? Because then the prosecution is going to say, well, what about this text message? And what about this phone call? And what about this recording here? And they're going to go through all of those items line by line, brutal email by brutal email. It is not going to be pretty. It is going to be very difficult. Okay. Yeah. Y'all are asking some really good questions over here. Let's see where we're on Mildred. So Nina is saying, I'm sorry, but I feel bad for her, the pressure. I'll be honest, Nina, me too, because I would not want to be in the, I'm terrible at those decisions. So that would be brutal for me. And I'll get to your other decision.
Development, Ms. Fulford, Mrs. Adelson, the extra time that you've been provided, that has come to conclusion. We are not finished with the colloquy quite yet.
Pinky, I agree with you. It would be so
We're
exciting.
not talking for the sake of talking. Before we have to move into any contempt, we do need to move on.
There's your answer, Grillsy Lou Bear. He would hold her in contempt.
Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Okay. No testifying.
As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
This is it.
Say that, Judge. May I have a moment to confer
Oh.
with the counsel?
Oh, well, that was maybe a little unfair, but now she might actually decide. So let's take a quick tour through the comments over here, over in the super chats. Grillsy Lou Bear, I didn't know what would happen either. I was like, what is the judge going to do? She just won't decide. And he said he would hold her in contempt. So that was the plan if she didn't answer, which she did. She said, I don't want to testify at this time. Probably the wisest decision. I don't think she would have helped herself. And it would have been brutal. Hru, I have never seen this before. I have never seen this level of indecision. It's like me trying to make a decision like that. I am very indecisive. So I have never seen that before. And wow, it just about didn't happen. Cheryl thinks that the only question the defense needs to answer, did the state leave reasonable doubt? If so, no need to testify. If the state proved its case, she has nothing to lose. So it is true that that's absolutely the standard, the reasonable doubt standard. And so I'm sure they are debating back and forth over this. But Donna, I mean, I wonder what it would feel like at this exact moment for Donna Adelson. She's made the decision not to testify, and she.
I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors. Or we can decide the language now. If you find that more acceptable, it's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. And we'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Wow. Absolutely. We are at the end of the case.
Do you have another witness to call?
That's what we need to discuss, Your Honor.
They might have another witness to
We've
call?
done a lot of conferring. Please quickly
What?
come to a decision as to whether there is another witness, in fact, for the defense.
Is it Harvey? Who is this other witness? So there is I don't think I've ever seen this much uncertainty at the end of the trial. No one can decide. Are they resting? Are they testifying? No one knows. And we all wait. But it sounds very likely that by tomorrow morning, we're going to be having closing arguments in this case. It's happening. We are finally at the edge, the very end of the case. All right, so Jacob would have asked the judge for until a.m. They did. They asked the judge, they asked as many ways as they possibly could for more time. And he was no, 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 and gave him 5 minutes. That was all he gave him. They wanted more. Paula D is not buying that it's in that she's having trouble deciding. She figures this is part of an act too, part of the Adelson acting school. So could be. Retired cheesehead. Thank you. That was just a super sticker. I appreciate that very much. Janet thinks that would be the hardest decision ever. That's kind of my view. I think that would be so hard. And it doesn't matter what you decide. You're going to regret that decision. I would be second guessing it anyway. Very, very hard decision. That is so nice. What a lovely comment, Mom. 2 field spaniels. That is so nice. What a nice comment. So we wait, but we are at the edge. We are here. We have finally reached it. I bet they don't call another witness. The state isn't calling one. There's a single stipulation that Patricia Byrd was never listed on the defense witness list. That became a question when everybody was talking about whether the state had notice that Patricia Byrd was going to potentially testify for the defense and that sort of thing. But they agreed now she wasn't listed on the defense witness list. So that issue is off the table. So here we are waiting once again for Donna Adelson and her team, wondering what they will do, what they will decide. It has been it's just been a bizarre day. This is one of the strangest trial days I've seen. Nothing has gone quite as I would have guessed when we walked in this morning, when I clicked on hello, welcome to today's live stream. I would never have guessed what was happening today. This is just not what I thought. I am curious. Now that the decision is made, let's go ahead.
Is there another witness to be called?
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualify under hearsay exceptions. State's indicated that they're objecting. If I could just have a moment.
Okay. There are two exhibits they want to tender, and the state is objecting. So he's trying to figure out how he gets those in, I suppose, or whether he really needs them. And then if so, they may have an argument. But he didn't name another witness that I heard. I don't think they're going to have one. I think this is it. Well, they've led us on a merry afternoon, haven't they? Trying to figure out what they're going to do, whether we're ending the case. Tomorrow, opening statements, almost surely, even if he has one more witness, tomorrow, opening statements. I honestly don't think it would have made a slight difference if she had testified. Not at all. If anything, it would have hurt her. I think it was probably the right decision. I know she'll second guess it. Maybe I should have, but I don't think it would have helped. And the cross would have been utter destruction. It would have been also another way that the prosecution could walk the jury very cleanly back through all the evidence. So they'd get not just closing argument, but they'd get the cross of Donna Adelson, get to do it twice. I think it would have been brutal. I think the decision was right. I just think it was a hard decision, and I can understand that. She didn't have some specific theory she had to bring, and only she knew, so it wasn't necessary, and it almost certainly would have been very destructive for her case. Although I have to say, I was really looking forward to that. I was really wanting Donna to testify. And how do I know you were too? Because we did our poll early on. We talked about who did you most want to hear from. Donna Adelson was the person you most wanted to hear from. I'm surprised at how few of you were.
Concerning the items, we do need to move on so a ruling can be made.
The judges, he's not cutting them any slack here. They're taking all this extra time. I don't know why they have to confer with Donna. They just need to get the exhibit admitted. Is it that only Donna can testify about this? Don't put her in that spot. Do not do that. Can you imagine? And then she says, okay, I decided to testify after all. Oh my gosh. This is crazy. This is the legal equivalent of double overtime. The game is going on and on.
Your Honor, yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar that is I believe it's states 51.
They're wanting the whole exhibit admitted, which I bet there's objection to. Switch the view. I don't know for sure why they want that, but they may want to point to the idea that in this calendar, other license plates are written, other tag information is included. Why she put that kind of stuff in her calendar all the time. And they may have wanted Donna to testify to that since she's not going to be able to. They might just point it out in closing. Why, look, on page 42, here's a license plate number, and on page 53, here's another. I guess.
Concerning these items was the state's argument.
State's objection is hearsay, Your Honor, and the portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar, it's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
He may explain why he wants it.
2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country.
Yeah.
Contrary to that, there are a ton of pages going back to January 9th of 2023, where my client lists those very same items to get prices to sell, to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes.
Who was going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state. It was seized
I
by.
believe as the
Interesting.
inculpatory matters, yes, as to whether or not she was planning to sell something in January of 2023. What witness testified concerning that?
Judge,
Here's the rub.
The implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously.
Well,
Not
wait a
that the
minute.
truth of the matter asserted. Not that she was.
Hold on, these are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witnesses lay the foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. These are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research. But again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue in closing. It's the same argument as the 2014 calendar.
Just one of
Okay, so what that was about, remember the planner that had Dan Markel's license plate written in it? What they're trying to do is get in other parts of that planner without Donna testifying. So if Donna had taken the stand, it'd be very easy. Is this your planner? Yes. Did you write down this list of things you wanted to sell all the way back in January and just kind of carried it through? That's how my to-do list look, I will say. You know, I never cross anything off. I just keep moving it along. So they're trying to say these weren't, she wasn't selling items to flee the country. She had these on a to-do list since January. She'd been meaning to sell them all along. So you would also find the same items listed at other points in the planner. They want to get that planner in, but the only part that was identified was put in through a witness who identified, yes, this is the license plate number of Dan Markel. And nobody identified, yes, these are the list of items that you want to sell. That was very specific as when it was put in. That was really specific. Now she wants to get in other parts, and the attorney has argued, as a matter of completeness, if it appears more than once in this planner, you need to put every single entry in. And the judge said, well, there is such a thing as the rule of completeness in law, but that applies when you have one document and you're leaving out part of that. But when you have a planner, it's more like a lot of little documents. It's not, you can't just say, well, if one tiny entry comes in, then the whole planner does. This is one of the consequences of Donna Adelson not testifying. If she chooses not to testify, then that creates some problems for the defense. And one problem is going to be that they're not going to get this in. The judge said he'll consider it, but he's inclined to not let them use or put in anything in evidence other than that. Hey, Heather, that I believe you are looking at Dan Markel's mother. I believe that's who you're seeing in the sunglasses. She's a little bit to the left of the picture where we are right now. Welcome to Yeehaw Blondie and Pandora's Box as members. We are so glad to have you. Lisa, such a good point. They had an inmate. I think her name was Heather Washington or something like that. Anyway, she was supposed to testify that the snitches.
Excuse me, Your Honor. The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I can identify the items that I think should be redacted. The specific purpose of offering 2014 materials has to do with planning the 70th birthday party of our client's husband. And specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that was not already made?
only entry from a 14 planner that was admitted, has been admitted so far in this trial is a page that shows
The license plate
the
number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 plan in its entirety has not been identified at all. Only that page was identified. 23 planner was identified as by a witness as it being seized from the residence.
Was there a ruling as the 2014 planner as well? Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor, and for the record, what I've done is I've marked the 2013 excerpts as defense, 2023, sorry, as defense 51, and 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense mentioned.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
Who have gotten their exercise today. Oh, man, out of the courtroom.
I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct.
Yeah. Jurors are fine to come in.
All right, you're entering the courtroom.
Defense may call its next witness.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties. And from there, tomorrow, you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
Because there will be a lot of arguments last minute, probably, almost certainly. He'll try to get them all done today, but there will be more stuff to pop up. So this is it. This is the case against Donna Adelson. It's reached the end. Donna will not testify. Charlie will not testify. Harvey
Seated.
will not testify.
Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes?
So let's stop for just a minute there. So let's talk about how momentous this is, because the final decision was made. It was painful. It was really difficult for the Adelson side to decide, would she testify or would she not? It's going to have some consequences, but I think overall probably a wise move, because I cannot imagine that having gone well. We have reached the end of the case. There will be no more evidence. We are about to have the final arguments about what the jury is going to hear, about the jury instructions. But this part of the case is over, and we are now moving into the final stage. Jury instructions, closing arguments by both sides, and the jury deliberation. All right now. It is all happening. So today, We're going to continue to listen as they go through the jury instructions and have their arguments about what would be important, what would not. Then tomorrow morning, first thing, as soon as they can stop arguing about all the little extra stuff that they'll have built up by tomorrow morning, when they finish that, we are going to actually hear the jury instructions and the closing arguments. All of that tomorrow.
Being sought.
It can be really hard to follow this if you don't have it in front of you.
3.2, statement of the charge. Any requests or changes?
Your Honor, the only request that I would make is that the name of my client and the names of the charges not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note.
So far they've changed that they aren't going to put the charges in all caps. So it's not going to say murder in all caps. That's it so far. Doesn't seem like a super big change.
Moving on to 7.1, introduction to homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
As to the next paragraph concerning lesser includeds, is the defense asking for all category 1 lesser includeds?
So they will have lesser includeds of some form. The question is, all of them or only some of them? The defense is considering that. Oh no, not another decision. They have decision fatigue. Here's what I'm going to do in just a second. I was thinking they would go ahead and give us the answer on this. Tell you what, we'll stop it for a second. I want to talk. So I think what we'll do, we'll stick with this for a while as long as we're able to understand enough of what they're saying. If it reaches the point where we can't really understand because they're referring to, what about paragraph 3? And we don't know what paragraph 3 says, then we'll let that go. This is a super important part of a case. It's also really hard to watch. It's not easy to kind of observe, like, say, a witness testifying would be. This is the part where they're going to tell the jury what the law is. That matters a lot, but it's also something that is pretty in the lawyers' heads on the piece of paper in front of them. It's hard to follow sometimes. It matters because it's going to influence the jury. It's going to set the boundaries and parameters for the jury. Although in truth, by now, many jurors have already, studies show that jurors have mostly made up their minds, and they made up their minds fairly early on without having heard all of the instructions about the law. That's what studies show, practically speaking, whether that should be the case or not. That actually does tend to happen. So but they will think that this is really important. They are going to listen to that and try really hard to follow it. At least most juries do, I think the vast majority. So they're going to go through these, and it'll be a lengthy list of them. It sounds like the judge has given them some forms where he has written out what he's going to say, and then they're going to make objections, argue about it. There will be a lot of sitting around, but while somebody thinks about it, like we are now. But so we'll keep doing it as long as I feel like it's helpful and we can make some progress with it or learn something about the case. When we reach the point that we don't, here's what I'm going to do. I'm going to do the recap for the day. This was a very, very strange day. If you missed any part of today, you do not want to miss the recap, because wild. That's all I have to say, because wild. And what I'll do at the end of the day, when we shut this down, I'll download that part and I'll re-upload just the summary. So if for people who don't have time for the whole thing, which personally I love having you along and I'm glad you're here with me, but if you don't, then there's always a recap. So that's kind of how I've been doing it. Tomorrow's a huge day. Tomorrow is the day. We are going to be hearing closing arguments. The jury is going to be getting the case, all happening tomorrow. He hasn't said how long the closing arguments will be. I wonder how long that will take. I can't remember how long Charlie's were. It seems like I remember them being fairly long, maybe an hour and a half, but I can't remember for sure. So, but it'll be tomorrow. And I mean, this judge is not exactly somebody to sit around. So I think we will actually find that the jury gets the case tomorrow and begins deliberations. I'm going to speed it up and we'll see how much talking there is versus how much sitting. It's really hard to hear. Nobody's bothering with their microphones. Well, I guess we could do questions, but what will happen is they'll keep interrupting us. I was answering Lisa's question. Yeah, they were supposed to have another witness. They were supposed to have a witness who was going to say that I knew it.
As to the second degree, lesser, are you requesting that as well? It's category 1.
Although it's a category 1, the lesser still carries the same penalty. So you're not requesting.
Here, I'm going to do it this way.
Is the state requesting second degree as a category 1 lesser?
Yes, sir. Yes, sir. We'd be requesting all that.
Well, all category 1 lessers will be given. Second paragraph will read in the introduction, first degree murder includes the lesser crimes of second degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
Okay, we'll do a poll. Tell me what you think. Tell me what you want.
If you find Daniel Markel was killed by Donna Adelson,
It's going to be close.
you will then consider the circumstances surrounding the killing and deciding if the killing was first degree murder, second degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but as either party requesting.
Okay, I'm going to pause it there. To finish with the witness that Lisa brought up, this person was going to say that at least one of the 2 jailhouse testifiers, one of the witnesses, Drina Bernhardt, had admitted that she was just doing this for the sake of getting a deal. We don't know a lot about what she was going to say because it isn't like she actually testified or made a proffer, but we do know that the defense had talked about her and said she had gone to the state with the story that Drina was bragging about this and that she was going to testify for the defense, but she didn't come. I don't think that's the same person they were talking about who, when they talked first thing this morning, it sounded like that was an officer, not a prisoner. So I don't think it was the same. Nina, very good question. Wouldn't cross be limited to what the direct was? And yes, that's exactly right. The cross-examination is limited to the topic covered on direct. When you've got somebody, though, like a defendant, it is so easy to cross those borders and to accidentally open the door to a topic you didn't think you were asking about, but that ends up being now something the state can ask about. But yes, that's exactly right. And that's a really good point. For the recap, says X Bad Bunny X. Let's do recap. Let's see. The poll. Well, we do have a winner so far with 441 votes. I think I want to go ahead and do the recap. So I appreciate very much your advisory vote here. Y'all are leaning toward the recap. I'll go ahead and close it out right there and see where you ended up. So on the recap, it should pop up in just a minute. Recap 58%, jury instruction argument 41%, which means some decimals were involved. It's not always an even split. Here's what I want to do. And I want to go ahead and do this while I'm fresh enough to pretty much cover the day pretty coherently. I think that'll be better. And I think that it doesn't sound like we're going to be able to get a lot from these jury instructions unless you have them in front of you. It can be really hard to understand the arguments that are being made. And there's a lot of sitting, watching them read it. So we'll hear them tomorrow. And I may come back and do something else with that. But I think for now, I really want to get the recap in. So let's do that. I think it's going to be really important. So let me make sure, are there any people over here I have not addressed? So when I finish the recap, my plan will be to go ahead and I probably won't be doing more questions after that. We'll do questions, of course, tomorrow. We'll probably have some sitting around time in the morning while we wait for everything to happen. But this has been a wild day, and I don't want any of you to miss what the recap is going to be because it's been huge. So this has been just a crazy day. So what I'll do is just start over. If you'll bear with me, it'll sound like we're restarting at the top of the day, but all I'm doing is having something I can cut out and still have people understand where we are and what we're talking about. All right. All right. This is always that moment right before, oh, thank you for fixing that for me. Yes, it would have been in the wrong way. Let me pull Bad Bunny out. I like the name. Okay, so hi, y'all, and welcome to the recap of day 8 of the Donna Adelson trial, which is without question the strangest, most bizarre day of the entire trial. It was strange start to finish, including the enormous angst that Donna Adelson displayed over whether or not she should testify. It went back, it went forth. Would she testify? Would she not? We waited for all day, and the judge gave her 5 minutes more to decide, and 5 minutes here, and finally the decision came in. Donna Adelson, spoiler alert, will not testify, but we are moving straight into closing arguments in the morning. You've got to hear about today. It was absolutely crazy, and it started out of the gate. The first thing was so bizarre. When the court feed cut in, it cut in with a statement, something like, from the defense. Well, we're not accusing the prosecution of doing something to prevent us from talking to witnesses. What would even think that? Apparently, there was a person at the sheriff's office that they were supposed to speak to. Sounded like an officer working with the sheriff's office. They went to speak to that person, and for some reason, they believed this person had information and was willing to talk to the defense. But what happened was that the officer announced they were no longer willing to speak with them. Apparently, they weren't even allowed to see the officer. They just got the message the officer was no longer willing to speak to them and was not available, was on leave. So shades of something like we might have seen in Karen Reed case, right? This is sounding like the sheriff's office is getting in the way of Donna Adelson being able to get information. Are they withholding? Is there someone who has important information and they're not letting them have this? But it quickly devolved from there. The judge said, well, okay, do you have her under subpoena? And they said, no, we haven't even talked to her. We don't even know exactly what she's going to say. And maybe we don't want her under subpoena. because it's not good for us. So no. And the judge said, well, okay, this is like, we're in the middle of trial here. And this is a brand new witness. And it's furthermore a witness not even under subpoena. So we got into the argument. It apparently was a deputy named Franklin. And they put the sheriff himself, I believe it was the sheriff himself, under oath. And the sheriff testified that Deputy Franklin went to her captain, who came to him, and he talked to the legal counsel for the sheriff's office. And here's what they came up with. She had come to her captain and said, do I have to speak to these guys? And the sheriff and the counsel said, you can if you want to. But if you don't want to, then the defense is going to need to show you a subpoena in order to make you testify or talk to them, I mean. And so then the defense, after all of this, the defense said, well, we just wanted to put it on the record. We're not going to pursue it. So I don't think it will be an appellate issue because they aren't going to pursue it. And they weren't even going to be talking to the person. So what was that about? We will never know. The next witness, and there were only a couple, well, no, there were a few more than that. The next witness was Kristen Adelson. All morning was attorney morning. We heard from attorneys. Both of them were family law attorneys. The first one, Kristen Adelson, represented Wendi Adelson. And Wendi was, of course, the daughter of Donna Adelson, who's on trial, and was in a bitter custody battle. Well, at least I've called it repeatedly a bitter custody battle with her ex, Dan Markel. But the point of both of these witnesses was to say it wasn't really that bitter a custody battle. It wasn't even that big a deal. And it wasn't all that hard fought. Everybody seemed to pretty much resolve it and get along. That was a large part of what these witnesses had to say. So Wendi's attorney said she would not call this a bitter custody battle. She said, yeah, they had an argument over relocation. And she told Wendi that you can ask for relocation, but you're only going to get one shot at that. You have to do it during the divorce proceedings. Doing it afterwards, getting a modification, you're never going to win that. And it's going to be hard to get even initially out of the gate if you ask for it in your divorce proceeding. She told Wendi, in my entire 37 years of practice, would have been fewer then, I guess, but as of today, she said, I've only won relocation once. So this is very rare, very hard to get. So the hope that Donna and Wendi had of getting the kids to be able to move to South Florida, nearer Donna and Harvey, that wasn't going to happen. Not through the courts, not through this motion, very unlikely. And sure enough, to no one's surprise, except Donna and maybe Wendi, but certainly not to her attorney's surprise, Wendi did not win relocation. She did not get the judge to order that the kids could be moved to South Florida. So Wendi could still offer a financial incentive to Dan to move. And that was discussed in the family. We have often heard it referred to by the state as the $1 million bribe. And they've said that if they could pool their money, Donna, it depends on who you ask, but Donna and Harvey would pay a third, Charlie would pay a third, and Wendi would pay a third unless you asked her, in which case Donna and Harvey were both paying a third and she was paying nothing. But they were going to offer $1 million to Dan Markel. This was Donna's idea, not necessarily anyone else's. But if they offered this $1 million, it would be, according to Wendi, a way that Dan Markel can move to South Florida and still travel back and forth to his job. So he would be living near the kids. There wouldn't be a problem with seeing them. The only inconvenience of traveling to Tallahassee to teach his law classes would be that he would have to incur some expense, and that would be covered by the money they were going to provide, this $1 million. And the attorney said there's nothing wrong with that. It's pretty common to try to, it's a negotiation. You're trying to work out getting where the kids will live. So if money makes it easy, you just try to figure out how to make it all work. Now, of course, we know that Wendi testified that she never even brought it up with Dan, and it might have been an idea Donna had, but it never even got mentioned. It never got out of the gate. We did get one weird fact I don't recall from before about Wendi hosting a party after, I think it was a couple of months after the divorce was finalized. It was called the Wendi gets her groove back party, and Wendi invited her attorney, the same one we were hearing from, some friends, and she was celebrating her new life. Nothing wrong with that. I don't remember hearing that detail before, or that the attorney was invited to it. The cost of this litigation with Dan Markel, the attorney said, was about $30,000, which wasn't that much compared to a case that really went through litigation, meaning went through discovery, went through the trial process. That would cost a lot more. At the end of it, there was a deal where Dan Markel still owed some money. Two things in particular. He was going to pay Wendi $120,000, which he did not. He was also going to pay her attorney $10,000, which he did not. Those amounts were outstanding, and the attorney said she asked repeatedly for them, tried to push for them. He wasn't paying. At long last, she finally moved to force him to pay that. It was a motion for contempt because that's what you call it. But we were told it's not the kind of contempt where somebody goes to jail. At that point, Dan Markel came up with an argument. This is her. I'm describing to you what she said, okay? So you can understand what was said by the witness. Dan Markel said he really shouldn't have to pay that money, although the witness said he had fully agreed to it in mediation. It was part of the order. He had to pay it, but he shouldn't have to because it turned out Wendi had hidden certain assets. And the attorney for Wendi at the time, Kristen Adelson, said that was false. We have been in the middle of a mediation when issues about this arose. We called the person from Charles Schwab. We got him to detail exactly what accounts there were, who owned what, which ones predated, which ones were marital assets coming in the marriage, which ones were non-marital assets that were not going to be shared. And we got it all worked out. That was part of the deal. We were not hiding assets. They were divided as appropriately in the middle of the mediation before we ever settled anything. The witness said, and we heard this from the second witness as well, that she believed it was Dan Markel writing these motions, that it just sounded like not a family law attorney. It seemed more like Dan was doing it. The judge's reaction, according to Kristen Adelson, was to be very unhappy with Dan Markel and Dan Markel's pleadings, that they were not appropriate. And to tell Dan, this is not the way it's done. Dan Markel around this time began bringing up parenting issues, and he filed a motion and asked that Wendi and her attorney be disbarred, saying they had committed fraud. He also talked about parental alienation claims. These were claims that Donna was making statements to his children with Wendi, and they were statements about him that were negative about him, like that he was dumb and trying to take her loves away. I've forgotten her word for them. I always forget that one word. But the attorney told us that it would not reduce Donna's time, that this motion was absolutely nothing. This idea that Donna was alienating their affections for these comments, that's not going to reduce her time. And Kristen Adelson said, I told Wendi that. I told Wendi this is a nothing. Do not worry about this. So at this point, though, Kristen Adelson realized she was going to have to be a witness. So she withdrew because now she was going to have to testify in the case, and she couldn't both testify and also be the person who represented Wendi. She had to do one or the other. So she had to choose to be the witness, and she got someone else involved to represent Wendi. Donna was not overly involved in the case, she said. In fact, Donna, the only thing she really ever heard from Donna was that Donna came to the relocation hearing. She thought she maybe stayed outside. And Kristen Adelson said, as divorces go, this was not a particularly contentious one. The enforcement, when they got into the part where they were fighting and Dan Markel was filing his new motion, yeah, that was pretty contentious. And his pleadings were very personal. But frankly, that was Dan, not Wendi. And that was Dan doing it after the divorce was finalized. So again, remember, I am recapping for you what happened in the day. So you were hearing my recap of what the witness said while the witness was testifying. Don't worry, we will get to cross-examination. You will hear what happened on the flip side as well. So, so at this point, and frankly, the next witness was the one who mostly that the state asked the questions and discussed how the response would be for the state. So we'll get into all of that. The next witness was Linda Bailey. She testified to almost the identical thing that we just heard from Wendi's lawyer. She testified to all of that related to the question of what exactly Dan Markel had done, what they had agreed to, and what this grandma motion that we've heard so much about from the state, what did that actually mean? So Linda Bailey followed up. She was an expert witness. She came right after Kristen Adelson. So the majority of the state's cross-examination happened during that cross-examination. You'll hear all of that. But Linda Bailey, apparently, and boy, did this get the judge upset. Linda Bailey was in the courtroom during the testimony of Kristen Adelson. Now, in this case, there has been a rule of sequestration was invoked, meaning that the witnesses can't hear each other. So a witness has to stay outside the courtroom and not hear the testimony until it's time for them to testify. And then once they finish, if they're released, they can hear what everybody else has said. But what they can't do is come in, listen to the testimony, and then potentially have it affect what they said or what they thought or what they remembered. That's the reason for the rule. Well, in this particular case, there was an exception made to this. The exception was that the experts for one side could hear what the experts on the same topic for the other side said. The defense asked for an exception, and that's the part that the state agreed to. So that was the part that became the exception. The defense wanted more. Apparently, this witness, Linda Bailey, all along wanted to listen to Kristen Adelson, but that wasn't what the state agreed to. And so what you had was Linda Bailey listening, even though that hadn't been agreed to, and she wasn't supposed to under the agreement they had made. So at this point, the judge said, this is not what the state agreed to, went back and looked specifically at the transcript where there had been discussion between them, what had each side said, and said, look, this is the second time, defense, that you have violated the exclusionary rule. This is the second time you've let someone listen to testimony when they're not supposed to, and thought long and hard about whether to let this witness in at all. The state said exclude the witness. She heard testimony she wasn't supposed to, keep her out. So there was a proffer at this point. That means they offered some evidence to give the judge an idea of what he would be ruling on. And of course, it'd be available for appeal as well. The jury didn't hear this part. So the witness, Linda Bailey, came in. She's an attorney as well, also a family law attorney. And she said she had asked to be able to sit in to Kristen Adelson, and that she wanted the reason she wanted to sit in for that was that she wanted to confirm she had all the facts correct, and she concluded that she did. The state said, and the state did one question for her on cross-examination during the proffer, was there anything new that you learned? And the answer to that was no. She said, no, there wasn't. So the judge came back with some findings. He said, look, I'm finding this is a second violation, second time you've done this in this trial. And you could tell he was upset too, may I say. And he said, Bailey should not have sat in the courtroom. That shouldn't have happened. But here's the deal. The test set out by the appellate courts for me to follow was the testimony substantially affected by what the witness heard? And did it differ from what would have been said if they hadn't heard it? Well, that's a really, really high standard, and essentially means that unless something unusual is going on, rarely should they exclude anyone from testifying. And the judge said, look, she's got credibility. She's a member of the bar, so I'm going to assume that what she told me is correct. And what she told me is she was not substantially affected. So I'm going to let her testify. but I'm going to give the jury a special instruction at the end about the fact that 2 witnesses violated this rule and heard testimony when they should not have. So we got finally to Linda Bailey, family lawyer, and she said that 40% let me rephrase that. All along, Wendi was really not trying to force a very unreasonable deal on custody on Dan Markel. That she was offering him from the beginning 40%, I think it was 41%, and that was not preventing him from substantial, she called it time sharing or custody of the children. That was pretty good. She wasn't being unreasonable in what she was asking. In the end, they worked out 45% to Dan, 55% to Wendi. The attorney, Linda Bailey, said, look, this wasn't all that highly contentious, and it was moving fairly quickly as cases like this go. It was 10 months and it was done. Donna's involvement also was, if anything, understated. A lot of mothers get involved. Donna was not unusually involved in the case. She looked also at those motions that Dan Markel filed in the last, 10 months or so, maybe a year. And she said she agreed that Dan Markel was drafting them. They did not look like anything an attorney who had any skill or knowledge in the area would understand because they didn't fit with the way family law works. They might make sense legally, but in general, but not as far as family law really works. That she said that as far as Dan not paying those amounts that he was supposed to pay to Wendi, the amount that he was supposed to pay to her attorney, that she thought that Dan's argument that I don't have to pay that because Wendi withheld information, that was not a strong legal position. He was not very likely to win on that. That Donna emailed Wendi just a few days after the relocation was lost. And yes, at that point, she was really thinking they could still fix this. There was a chance they could maybe make it work out. And Wendi responded to her, look, Mom, I'm at peace. I'm good. And at that point, Donna, from the review of emails she'd seen, seemed to drop it. And they managed to split custody fairly evenly, 45 Dan, 55 to Wendi. And after 3 years, it was going to go to an even 50-50 once the kids were in school. Dan Markel, on the other hand, she said was asking for something highly unreasonable, like sole decision-making for the children. She said, that never happens. That is totally out of the question. No one was going to do that. And her final judgment, the final judgment in the case, was favorable to Wendi, but only in the sense that Dan was asking for really extreme things. It was very fair and very typical. That Donna had grown to accept that Wendi was going to stay in Tallahassee, and that it's very reasonable and normal to pay someone to relocate. She didn't see anything unusual about that he did. And she talked specifically about the grandma motion, because this is at the heart of the state's argument about why Donna would want to murder Dan Markel. After all, what's the reason? And what the state says is he was standing in the way of getting those grandbabies down to South Florida where she could spend more time with them. She didn't want that. And so having reviewed what he had filed, Linda Bailey said, well, he wasn't asking for her to not be allowed to have unsupervised visitation. That's not what this motion really says. That, first of all, it was 8 points down, 10 pages into the motion that he filed. And it never said anything about Donna not being allowed to have unrestricted time or always having to have supervision when she was with the children. Instead, what it said was that instead of Donna coming up and getting the children when Wendi went out, basically being the babysitter, instead, the right of first refusal would belong to Dan. So if Wendi was going out, he would get to say whether or not he would get to be with the kids or not. Although you can see if someone was really committed to that, then you can see where it would be hard for there to be any time left over to spend with the grandparent. You can see where that could go fairly far. The witness said, well, that's not how right of first refusal works. Said that this is not designed to prevent you from having sleepovers with your friends or from spending the night with grandma. This is supposed to be about longer term, bigger issues. That entire motion by Dan Markel that included the grandma motion part, it would not have been well taken by the judge, according to Linda Bailey. It was baseless, and she called it a complete waste of time and money, that it was ridiculous. It was not going to get accepted by the judge. During this period, while the jury was out, one of the attorneys, Jackie Fulford for Donna Adelson, asked for a sidebar. And when they came back, the judge made a very stern instruction, more than once today, might I add, telling the gallery, no expressions, no motions, do not do anything that could influence the jury. So cross-examination was fairly brief, but really powerful at the same time. The primary point of the cross-examination was, it doesn't really matter what Linda Bailey thinks, what Kristen Adamson thinks about whether this is an unusual case. What does matter is whether Donna Adelson thinks it's an unusual case, or forget even unusual case, whether she thinks it's bad for her and whether it gives her a motive. That's the real question. So at one point during the examination of Linda Bailey, we had kind of a my cousin Vinny moment. You may remember back to Charlie's trial, a moment when Georgia Kappelman brought up a big notebook of the file for Wendi's divorce case and plunked it down on the desk in front of her and said, is this your divorce file? Huge thing, right? All it was one notebook, granted, thick notebook, that thick. Well, they went through more details with Linda Bailey, the defense did, Donna's team, and they said total pages in her file was about 550. That was the file between Wendi and Dan. Whereas they brought up another file that Linda Bailey had worked on, and it had 10 notebooks. And she said there was another file she had that had 20 notebooks. Their argument being, this is a heavily contentious divorce case. That, the one with the 10 notebooks or the one with the 20 notebooks, that's big. That's really big. And they were stacking them up. They had boxes on them. It was definitely a my cousin Vinny moment. But the cross was just pretty simple. Okay. Granted, to you, it might take 10 notebooks to be a big case. Maybe it's not contentious to you until it hits 20, but that is not the point. The point here is what Donna Adelson's motive was. And specifically, Linda Bailey had said at one point that she had a witness, not a witness, she had been representing a woman, and the woman's spouse, soon to be ex-spouse, committed an unaliving because of himself, because he was concerned about the shame that could come from this. And Georgia Kappelman said to her, well, you don't see divorce as shameful. And she said, no, I don't. And you wouldn't do that. But it was to him. It mattered that much to him. And so that was how he reacted, even if that wasn't how you would react. And so the witness said things like, well, let me go through it as Georgia did. Said, wouldn't you admit that issues in these pleadings could make people really upset? Like the allegation that grandma is disparaging me. I mean, couldn't that be upsetting to grandma? And Linda Bailey said, well, it shouldn't have been. And in other words, saying it's not going to win. No one really thinks that. But Georgia Kappelman said, in your opinion, because obviously Donna Adelson might not know that, not having the same background. All right. So, but we were not done with the bizarre and weird things that happened today by a long stretch. There is a lot more to come. At lunch, I asked some questions of our group so you can kind of get a poll. I wanted to know, if the divorce was not that bitter, which is the point that they're trying to make, does that mean Donna doesn't have motive? And about 57% of you thought it was still possible for Donna to have a motive definitely possible for her to have a motive, even if the divorce wasn't all that bitter. And that then somewhat was 20%. So 77% of the people watching with me thought you can still have a motive if the divorce is not that bitter. That doesn't eliminate the motive for a murder, such as in this case. All right. Then I also asked, what do you think about these attorney witnesses? Were they effective? And 37% of you said not at all. 37% said not really. And then 18% said somewhat. And 6% said very effective. So I said, well, what about if you heard the judge give an instruction? Let's say you're a juror and the judge gives an instruction that someone sat in on testimony and they weren't supposed to do that. Would that be an important instruction to you? Would that make a difference? And 46% of you said very much. 26% said somewhat. And 14% said not sure. 12% said not much. Wouldn't affect me very much. So, but all day long, we were questioning, will Donna Adelson testify? Will it happen? What will be the result? And what we found out, and right after lunch, they put Donna Adelson, the judge put her under oath and made sure that she acknowledged and was admitting that she was waiving the attorney-client privilege of Marisol Descalzo, who represented her before and then shortly after she was arrested. I believe she said for the first 3 months after she was arrested. And then she was going on the stand this afternoon. So Donna waived the attorney-client privilege as to the things that were asked of her on direct examination. And at this point, Donna was saying, I don't know if I'm going to testify. I don't know. And the judge is like, make up your mind. Decide. This is the time. This is the moment. Let me know. So we proceeded through the rest of the afternoon. By the way, I asked, should Donna testify? It was a lot closer. 55% said no, and 44% said yes. But I think some of that may just have been yes, because I'd like to hear Donna, as opposed to yes on her own behalf. So we then moved into the testimony of Marisol Descalzo, who represented Donna Adelson from 2022 until 3 months after the arrest. She said that at some point there became concerns about Donna Adelson's mental state, that she was considering unaliving. It was of great concern. And their solution, she wanted to get away on a vacation. So where is this headed? Obviously to the question of whether or not when Donna Adelson was going to Vietnam, was she truly trying to flee the jurisdiction? Was she trying to get to a non-extradition country so she could avoid being prosecuted for something that she believed she was guilty of? Is this proof of her consciousness of guilt? That's what the state says. The defense is saying, look, she was going on vacation. Give the lady a break. So Marisol says there was, as far as she talked about this with Daniel Rashbaum, who was Charlie's attorney, and as far as I knew, there was nothing preventing Donna Adelson from traveling. There were no warrants for her arrest. And furthermore, Marisol had introduced herself to Georgia Kappelman and assumed they would contact her if they needed something, if they needed to let her know or ask for something. But she was very specific. At no point was she promised that or guaranteed that Donna would be able to self-surrender, meaning she could just bring herself down and just turn herself in. So on cross-examination, the Sarah Dugan handled this one, and she said, well, it's not necessary that you be notified before a client is arrested, right? And tried to get her to say that, in fact, that's probably not something you want to do when someone is maybe trying to leave the country. But the text that Donna wrote, where she said she was afraid she was next, but she'd take care of it, she asked about that. Sarah Dugan asked the witness about that. And the witness said, I'm not really familiar with that. I can't answer that. She said, look, we were worried about her in general. We were worried about her because she was worried about her son, not about conviction herself, but about her son. That's what we thought she was worried about. And we were told there was no warrant, but we warned her, both Rashbaum and I, that she could be arrested at the airport. and we didn't know. But as far as we knew, there was nothing holding her in the U.S. And that Marisol said she didn't know where she was going. She didn't know anything about non-extradition country or anything like that. So on redirect, they talked about the fact that Donna talked about vacation, not fleeing the jurisdiction. That's the point the defense wants to make. All she was doing was going out for a little break after the very difficult time with Charlie, and that extradition was still entirely possible. So even if Donna went to Vietnam, it wasn't like she had gone to the moon. There was still going to be the possibility of bringing her back and trying her in Tallahassee for this exact case. Maybe more difficult, but it's still possible. So the final witness, I believe this was final, was Sarah Newhouse. She was a victim advocate for Tallahassee back in 2014. She was assigned to Wendi Adelson on the day of Dan Markel's murder. Now, at various points, the defense has taken the position that the fact that Wendi was assigned a victim advocate is a sign that they saw her more as a victim and not as someone who is involved in the murder. I don't know if they made that as much of an issue in this case as in Charlie's, but it's been argued. But specifically, the defense wanted to ask Sarah Newhouse about the moment when Wendi called her mother. And Wendi called and specifically said, sit down, Mom. And Donna sounded shocked, according to Sarah Newhouse. It appeared to be the first time she'd heard about it. She sounded truly surprised by it. We did not see that moment during the call. They talked about it, but there was a little too much in it that the state wanted the sentence on either side of it taken out. So they're going to take those out, but they will be able to use that in closing argument if they wish to. So we then, and then we spent, I would guess, maybe it wasn't that long. It seemed like half an hour with Donna Adelson trying to decide whether to testify. And they went back and forth, and they said they needed more time, and this was really hard. And the state had presented 6 days of testimony, which is not really all that many, but they had to decide, and they didn't know, and they had to analyze it all. And the judge said, look, this is common to man. This is something every defendant has to deal with. Every defendant has to face the question of, are they going to testify or not? No defendant is given day of testimony for the state, full day to evaluate it and decide. There's nothing like that. Just when the state finishes and you finish your case or earlier, you have to make the decision. Are you going to testify or not? Give me your answer. And she couldn't do it. And they taught some more, and they had a sidebar and she couldn't do it. And they came back and it went on. And finally, these final 5 minutes, and it was not the first final 5 minutes they had. But finally, she said, I do not wish to testify at this time. I do not want to testify at this time. And there you have it. The end. She was not going to testify. But it was hard. It was not a decision that anyone on the defense team came to easily. Quite clearly, they were not sure what they were going to do. They were not sure if she should testify or should not. They immediately ran into a little bit of a problem with an exhibit that would easily have come in with Donna, but there wasn't anyone to put it in related to her calendar. I think they got it worked out for the most part, but they will be missing little pieces like that, little pieces where they're not going to be able to get a fact in. Ultimately, I think it was the wise call, because even though Donna Adelson, granted, could have gotten in some of these extra facts, on the other hand, I think the cross-examination would have been utterly and completely brutal. No question about it. I think it would have been absolutely brutal. So tomorrow we will be actually at the end of this case. We will actually have closing arguments. The jury will be instructed, and we will find out we may not find out the full answer, but the case will go to the jury tomorrow. As fast as the judge moves, my guess is that the jury will actually begin deliberations tomorrow. Now, in Charlie's case, that was super fast. We could actually have a verdict by tomorrow. We could know the result in Donna Adelson's case tomorrow. So do not miss tomorrow's live stream. We are doing gavel to gavel coverage, and it is going to be an unbelievably important case in the an unbelievably important day in the Adelson saga. So we will start in the morning when the court feed starts. I believe he wanted everybody there at 8:30. I can't remember for sure, but we'll start. We will start at the beginning. We will do gavel to gavel coverage, and I cannot wait to finish this and to watch this with you. If you would please hit the like button if you haven't already and subscribe. We would love to have you back for more. Here we go. Okay. Tell you what, I will stop it there and I'll go ahead and deal with anything left over here in the super chat section so that I don't leave anybody out. Okay. I remember we were on Bad Bunnies and Susan Shea, her hero. Oh, well, thank you. I'm glad to be, I'm glad to be one of your heroes. I'm glad to be listed. Sarah Dugan, Georgia Kappelman, and me. I'm highly, highly honored, Susan. Thank you. And Karen would have been lost without the breakdowns. I'm really glad. I really, really appreciate that. Such great feedback because that's my goal. I really want to be able to help people understand this. I find it absolutely fascinating. I am very honored that y'all will watch this with me because it's so interesting to me. So I'm glad to have you along. And Marion, thank you for the super sticker. That is much appreciated. Sal has been a member for 2 months. I'm so glad. Thank you very much. All right. Well, I am calling it a day. I am worn out. It's been quite the day. I really appreciate your being with me, and I will see you tomorrow. Do not miss tomorrow. It's going to be huge.